I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview.
All right, so I'm going to reserve ruling as to the deposition issue based on some evidence that's going to be provided as far as the motion to revoke bond. There's been a stipulation between the state and the defense, and Mr. Flowers, you're going to send me that proposed order.
I will, Your Honor.
Just make sure you copy Ms. Leone so it's all the terms that y'all have discussed.
We'll be pleased to do so, and as always, appreciate the cooperation of the state.
All right.
So, Your Honor, may I ask anyway, for the purposes of the motion to retake deposition, that at this time is denied?
I'm taking it under advisement until y'all have a chance to take a look at the evidence that's going to be provided.
Understood.
I just don't want it, if I deny it, then he has to file a new motion just to say the same thing that the current motion says. I'm just trying to save everyone a little bit of extra work.
Thank you, Your Honor.
All right, thank you. Thank you,
Thank
Mr.
you.
Earhart. All right, thank you, Ms. Chumbley. That's the conclusion of that case. Let me bring in Mr. Bass. Tell me we won't need him anymore, Officer Bass. We won't need Chad Bass anymore.
Yes, sir, if we could notify him, please. Thank you.
Bringing him in. All right. Looks like Sheriff's Office. All right, is it Deputy Bass?
Yes, sir.
Okay, your case has been concluded for today, so we won't need you anymore. I just wanted to tell you so you weren't hanging around too long.
All right, thank you. I appreciate it.
All right.
Have a good day.
You too. Thank you, sir. And that's all I have on Zoom. All right, Mr. Cotton. Sorry, you got kind of skipped for the Zoom call, but.
Morning, Your Honor. Byron Cotton on behalf of John Smith, case number 24-CF-0258. Your Honor, this is a VOP case. I've spoken with Mr. Sheik on this file. I anticipate a resolution by a plea in this case. I know you've got an 8/28 date. If we could set it on that. Well, and let me say this, Judge. It may be that we can resolve this sooner. I don't know what the court has.
I don't have anything sooner than 8/28 because the next 2 weeks are my civil trial weeks.
Okay, all right. 8/28 8/28 it is.
If y'all have an agreement that's going to get him released, then I can certainly try to take it on one of
That may
my.
come up. I'm not sure. He's got some, we're working on that, and my client's got some things he's going to follow up with me on about some decisions. And then I've got to follow up with Mr. Sheik.
Follow up with my office if it becomes time sensitive to not wait till August 28th, and we'll try to squeeze y'all in somewhere.
Okay.
Because I don't expect my civil trial to take all week next week. And then the week after, we've got a criminal trial special set, but I'm not sure how many days that's going to go. It's later on today's docket as well.
Okay. but you're here if we could get everybody here.
I'm always here.
Well, I know, I mean, potentially you might be in here to be able to do, obviously it's a felony, so it requires his appearance.
Yes, I just want to make sure we'll find a place to squeeze it in if y'all need it sooner than August
Okay.
28th at 9 o'clock.
All right,
All
that
right,
sounds
thank
good.
you.
We'll put it on that. You good? All right. That's all I've got before the court, Your Honor.
All right.
Good to see you.
Thank you, you too,
Yes,
Mr.
sir.
Cotton. All right, Mr. Hardy.
Vicente Ramirez. And Your Honor, we were here for a bond hearing, but we're going to enter a plea.
Okay.
We have-
To the two VOPs?
Yes.
Okay. Has he resolved his CT, was it a CT or?
This is going to resolve the, not the new law, but the VOPs on the CT and the CF. And Your Honor, that'll be on his probation. It'll be modified, first 6 months community control, followed by his original term of probation with all the requirements, and those will run concurrent. If I can approve.
How long has he been in custody?
Days.
All right, so it's modifying both cases to have the next 6 months to be community control, followed by the original term of probation.
Yes, Your Honor.
All right. Any issue with it being community control on the misdemeanor CT case that y'all are supervising? I think he does, because he just pled in
Probably does.
March.
Yeah, it's pretty recent.
March 20.
But yeah, we're not supposed to do.
That's fine. I mean, I don't think it's really going to change anything. I just want to make sure the paperwork is correct. I mean, it's going to be community control. It's just whether or not it's for two different cases or not.
Yes, Your Honor.
Okay. Do you agree with that, Mr. Sheik?
I do, Your Honor.
Okay, so that's the state's agreement is 6 months on community control after he's just done 31 days in jail for the drive-on license suspended. That's still pending.
Sure.
Okay. Is that going to keep him in
No,
that case? He's got a bond on that case?
he's got a bond on that, should be able to get out.
It's like an echo in here. All right, Mr. Ramirez, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. Okay. All right, Mr. Ramirez, you're here in 24 CF 750 as well as 24 CT 2044, which are both violations of probation. I've been handed a plea and sentencing agreement between you and the state that would call for you to admit your violation of probation and modify to the next 6 months will be community control on the felony case. Again, that's 24 CF 750, followed by the original terms of your probation with the original requirements that you were given back in March. And then as far as the CT case, I think it's just really placed back on probation.
It's got to be reinstated.
Reinstate on that. All right. All right, is that what you want to do, Mr. Ramirez?
Yes, sir.
And that was the state's agreement, correct, Mr. Sheik?
Yes, Your Honor.
All right. All right, Mr. Ramirez, have you gone over this plea and sentencing agreement
I have, sir.
with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
I did.
Are you satisfied with your attorney's advice and representation?
I am, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this admission to your violation of probation?
No, sir.
Has anyone promised you anything in return for your admission?
No, sir.
Do you understand by admitting a violation of probation, there won't be a hearing where the state would have to prove that you violated your probation?
Yes, sir.
All right. Do you understand that you're giving up all potential defenses that you may have in that violation of probation?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea to the violations of probation in 24 CF 750 and 24 CT 2044? Are you
No
admitting or denying?
Admit.
I'm going to accept your admission as freely, voluntarily, knowingly given. As far as the 24 CF 750 modified 6 months community control followed by the original term of probation, which will be reinstated with all original requirements to be done. And then on 24 CT 2044, just reinstate him to probation with the same conditions previously given. Adjudicated guilty, I'm assuming he was already due to the DUIs.
He was, Your Honor.
So we don't need fingerprints for him then. All right, Mr. Ramirez, make sure you go talk to probation quickly before you leave, and then you've got 30 days to appeal the judgment and sentence of the court. This is a guideline sentence based on the fact that he scores 22.8 points. All right, thank you, sir.
Thank you, Your Honor. That's all I have.
All right. Yes, probation is concurrent. Just the community control can't be on the misdemeanor. All right, Ms. Dudley.
First I have Jaquan Anderson.
Yes. Oh, Mr. Ramirez, there's going to be $100 cost of a VOP fee as well as, well, that should be it.
Your Honor, this is
Go ahead, Ms.
Jaquan
Dudley.
Anderson in 21 CF 2788, 2789. Your Honor, I have a plea agreement and a score sheet, if I may
All right.
approach.
Yes. Thank you. All right. Mr. Anderson, can you raise your right hand, please? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth?
Yaquan Anderson, 0730-1999.
All right, and Mr. Anderson, you're here in 21 CF 2788, as well as 21 CF 2789, both of which are violations of probation with 5 years of maximum exposure. Do you understand that?
Correct.
All right, and I've been handed a plea and sentencing agreement between you and the state where you'd admit your violations of probation. You'd be adjudicated guilty, sentenced to 18.75 months in the Department of Corrections, with credit for all time served, $100 VOP fee for each case. Those costs would go to judgment and revoke and terminate your probation. Is that what you want to do today?
Yes, sir.
Is that the state's agreement?
It is, Your Honor.
All right, thank you. All right, did you go over this plea and sentencing agreement with your attorney?
Yes, sir, I did.
And did you understand it?
I do.
Did you sign it?
I did.
And are you satisfied with your attorney's advice and representation?
I am, sir.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand that by entering an admission to your violation of probation, you're giving up your right to an evidentiary hearing where the state would have to prove that you violated your probation?
Yes, sir, I do.
And do you understand that you're waiving any potential defenses that you may have to your VOPs?
Yes, sir.
And do you understand that by entering this plea, if you're not a U.S. citizen, you could be deported?
Yes, sir.
All right. Just to make sure there's some kind of handwritten edits to the score sheet, it appears to be based on the fact that it was initially listed as a burglary of an occupied dwelling and switched to conveyance. Is that right?
Yes, it's the VOP points should be not for a violent felony offender of special concern.
Okay, so 12 instead of 24, and that's what gets it from 27 to 18 months.
Yes, sir, that's what we fixed, based
Okay.
on the charge.
I just want to make sure it's put on the record as because it's handwritten down there that that I didn't do it or someone did it without knowledge of everyone else involved. So,
Yes, sir.
all right, and so this is a guideline sentence of 18.75 months.
Yes, sir.
Yes.
Okay. And Mr. Anderson, what is your plea to the violations of probation? Are you admitting or denying your violation?
Admitting.
I'm going to accept your admission to the violation of probation as freely, voluntarily, knowingly given. Adjudicate you guilty, sentence you in each case to 18.75 months Department of Corrections, concurrent with credit for all time served, $100 VOP fee per case. All your costs will go to judgment, which means there'll just be a judgment when you are released that you'll have to pay, and then revoke and terminate your probation. All right. Anything that I've missed?
Yes, sir.
All right. Were there misdemeanors involved? Were there misdemeanors on those cases? I just want to make sure we're cleaning this up, or were those
It
time
should have
served?
already turned based on the time frame.
Okay,
Yes.
just want to make sure that's
Yes, sir.
addressed because they're still listed.
Yes, sir.
So he's already termed off of the probation for the misdemeanor counts.
Yes, sir.
All right, you've got 30 days to appeal, Mr. Anderson. Thank you.
Grantham? Yep.
Who do we have, Ms. Dudley?
Bill in Grantham, Your Honor. He's listed under Public Defender's Office.
Okay.
It's 24 CF 1482. I believe he's under Mr. Maddox. If I may approach, Your Honor?
So this is a new term of probation after the county jail?
Yes, sir.
Okay, just to make sure it's clear then, that the prior terms of probation were ECLC program or similar, reimpose all previous, just because there was a previous VOP, I'm trying to make sure all the, it's all tracking as far as what he's supposed to be doing on the probation, that it won't be a surprise at some point. So does this still involve community control in any way? Okay, because it was on community control. I was just
trying to I didn't see that the ECLC was a condition of the probation before, so that's why I was just confirming with probation.
Well, and that's kind of my point. So he initially, when he pled in February, it was to do drug court. Then there was a violation of probation. And in April, that involved him doing ECLC and all previously ordered probation requirements, to wit, cost of prosecution, court costs, PD fee, maintain employment, or submit 5 job applications weekly, weekly UAs for the first 6 months, then convert to random.
He understands that he has to complete that program, Your Honor.
ECLC?
Yes.
Okay. And that's why I'm just trying to
Yes,
make
sir.
sure, because if I just say reinstate all previous terms,
Understood.
it might be requiring him to do drug court and ECLC. So I'm just trying to make sure it's clear that he knows what the
Yes, sir.
the terms of his probation are going to be.
Yes, sir, he is aware.
All right. Mr. Grantham, if you could raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name and date of birth, please?
Dylan Grantham, 11/15/1993.
Okay, Mr. Grantham, you're here in 24 CF 1482 with a violation of probation. I've been handed a plea and sentencing agreement that calls for you to admit to your violation, be an adjudication of guilt, which I believe previously was a withhold. So that would be a felony conviction on the possession of a short-barreled gun or rifle. 4 months in the Okaloosa County Jail, credit for all time served, followed by 2 years of probation to complete all the original requirements, plus another $100 VOP fee. So the way I see that is it's Emerald Coast Life Center program that you must comply with, or a similar program. Maintain employment, submit 5 job applications weekly. Has he done the UAs for 6 months? I don't believe that's, I think it would have to be another 6 months of weekly UAs, since
Yes,
that's
sir.
the reason why we're here in the
Yes,
first
sir.
place too,
Understood.
right? All right, so it'd be, the first 6 months would be weekly UAs. Yes, ma'am.
It's all 4/30/2027. Just short of 2 years.
But it's a new term of
It's a
probation.
new term probation.
Oh, I'm sorry.
It's okay.
I'm sorry, I thought you said reinstated. I apologize, Ryan.
No, it's, I think I may have used the word reinstate as far as all of his initial requirements, so.
Okay.
But no, I appreciate you bringing that up, so we're all on the same page. That's what I've been trying to do up here. So it'd be 2 years of probation to start today, or when he's released. Okay. Do you understand the terms now, Mr. Grantham?
Yes, sir.
All right. Do you have any questions about that?
No, sir.
I just want to make sure it's clear because it's kind of relating back to some previous things that were done. So, all right, Mr. Grantham, did you go over this plea and sentencing recommendation with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
And you understand by admitting your violation of probation, you're giving up your right to a hearing where the state would have to prove that you violated your probation?
Yes, sir.
And you understand you're waiving all potential defenses that you may have to the VOP?
Yes, sir.
And you understand this will now make you adjudicated a felon on this charge?
Yes, sir.
And you understand that if you're not a U.S. citizen, this plea could lead to your deportation?
Yes, sir.
I just want to point out, because of the nature of the charge, that with the felony conviction, you can no longer possess any firearm. Do you understand that?
Yes, sir.
All right. All right. And what is your plea to the violation of probation? Are you admitting or denying?
Admitting it.
I'm going to accept your admission as freely, voluntarily, knowingly given, adjudicate you guilty. 4 months in the Okaloosa County Jail with credit for all time served, followed by a new term of probation of 2 years with a $100 VOP fee and the original requirements of your probation, which is to comply with the Emerald Coast Life Center program or similar, maintain employment or submit 5 job applications weekly UAs for the next 6 months, and then they'll convert to random UAs if you are successful in that first 6 months. And I believe that's the reason why we're here, Mr. Grantham, so
Yes, sir.
let's make sure that you're not only complying with the program, but learning from it.
Yes, sir.
All right. You can talk to probation before you leave, then I need you fingerprinted before you go as well. 30 days to appeal the judgment and sentence of the court. This is a guideline sentence
Yes, sir.
based on the fact that you scored 40.6 points. All right, thank you, Mr. Grantham. Revoke the previous probation to 2 years of probation.
And our next one I have is Dakota Josie. There's a waiver on files, 23 CF 1095, 23 CF 1330. Your Honor, could we set this for the 28th at 9, I believe, for resolution? So I can have Mr. Josie present. He doesn't live here, and I told him kind of late to make sure he gets here.
They'd have any issue with that?
No objection from the state, Your Honor.
I think we were just here last week.
Yes, sir.
So, where is he residing?
Bay County, I believe.
That far.
It's not, but I told him I told him kind of late because I didn't know if we were gonna have it worked out or not.
Okay. All right, August 28th at 9 o'clock
Yes, sir.
for a plea.
Yes, sir.
All right,
I believe that is all I have.
all right.
Thank you.
Thank you. All right, Mr. Browning.
Corey Browning for Stephen Poche. Judge, we're here on a motion to suppress in this case. The state's going to concede the motion. I think we've agreed that the evidence to be suppressed will be all evidence from the point of arrest of Mr. Poche.
That is correct, Your Honor.
All right, so anything post-contact, pre-arrest is still admissible?
Yes, Your Honor.
Yes, Judge.
Okay. If you could send me an order on that, Mr. Browning, run the language by Mr. Sheik. I understand what you're saying. It's always just better to have an order that says it, and send it to me in a Word format in case I feel the need to edit it further.
Yes, sir, word from that.
All right.
And Judge, based on that ruling, we're prepared to enter a plea this morning with Mr. Poche.
Okay. Is he here? Oh, okay. Yes. Sir, thank you.
At this time, Mr. Poche withdraws his plea and is not guilty plea and is a no contest plea to the
So what exactly is he pleading to on the DUI? He's pleading to a felony, right?
Yes, Judge.
Yes, Your Honor.
And so it'd be third outside of 10.
Yes, Your
So
Honor.
there's no mandatory jail for that reason, right? So I'm just trying to walk through it. We don't do a whole lot of DUIs in circuit court anymore. So I just want to make sure I understand that. So it's DUI, third offense outside of 10.
Correct, Your Honor.
Okay. All right, Mr. Pache, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth?
Stephen M. Poche, 3267.
And Mr. Sheik, you've confirmed these are the, at least the minimum mandatory terms for a third outside of 10?
Yes, Your Honor.
My concern with that is always that DMV might do something differently administratively, that we've got everything right, so Mr. Poche doesn't get surprised later by DMV.
I believe, just so, I think it is the fourth one, but it's outside of 10. Which is why.
And that's why I'm asking.
Because I think third outside of 10 is not actually a felony. Trying to remember.
So how are we doing this?
Yes. So, and that's why it is a fourth, but it is also outside of 10, which is why there's no mandatory jail time, Your Honor.
What if it's a fourth? Isn't DMV going to give him a permanent revocation?
Yes, Judge.
So even though I'm saying 6 months driver's license suspension, it's going to be, DMV is going to give him a permanent revocation.
It'd be up to DMV to, yes, we would put that on the record, Judge, that Mr. Bush understands that DMV will impose a permanent revocation.
But if it's a fourth, how am I not just announcing it's a permanent revocation? Say again?
We'd be fine with that, Judge.
Okay. All right, Mr. Boucher, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Let me just go through the terms of it because I didn't do that yet. But count one on the felony DUI, you'd be adjudicated guilty, 3 years of probation, multi-offender DUI school, $551.73 in court costs, 50 hours of community service work, which can be bought out at the statutory rate. It lists it here as a 6 months driver's license suspension, but my understanding it's going to be a permanent revocation by the Department of Motor Vehicles, and I have to order them to do that if it's a fourth. 2-year ignition interlock device if you're eligible for a driver's license. It's my understanding, at least, Mr. Brown, you may be able to correct me on this, that even on a permanent revocation, there's an application for a hardship license after 5 or 10. Okay. And 90-day impound of the vehicle, $2,000 fine, and you can certainly request early termination of probation, but it wouldn't be automatic. Do you understand all that, Mr. Poche?
Yes, sir.
Anything that I've missed, Mr. Sheik?
No, Your Honor.
All right. Did you go over this with your lawyer?
Sir.
And you understand and sign the agreement?
I did, sir.
I think I asked you that already, but I just wanted to make sure I get that. Are you satisfied with your attorney's advice and representation?
Yes, sir, I am.
Okay. And Mr. Sheik, part of the issue here is, as far as this plea offer, is because of the
Correct.
issues of the motion to suppress that the state stipulated to.
Yes, Your Honor.
I read the motion. I understand probably why the state stipulated to it based on my reading of it. Obviously, I haven't heard any evidence on those issues, but it was stipulated because of the reasons of the motion to suppress. All right. And are you currently under the influence of any alcohol, drugs, or controlled substances, Mr. Poche?
Yes, sir.
Are you currently suffering from any mental health issues or concerns?
Yes, sir.
And I haven't stated this yet, but the agreement calls for count 2 and count 3 to be dismissed. Is that right, Mr. Sheik?
That is correct, based off of the motion to suppress, Your Honor.
Count 2 and 3. I'm looking at the direct file information in Capias showing DUIs count 1. Drive-on license suspended count 2, refusal count 3, just to make sure it's clear. All right. And has anyone forced, pressured, or threatened you in any way, Mr. Poche, to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
Sir.
You understand by entering a plea of no contest as indicated by the form that there won't be a trial of any kind, and you give up your trial rights, which are listed on page 2 of the agreement that you signed.
Sir.
And do you understand you're waiving any potential defenses that you may have?
Sir.
Do you understand if you're not a U.S. citizen, this could lead to your deportation?
Sir.
All right. And what is your plea to count 1, which is the felony driving under the influence?
Contest.
I'll accept your no contest plea is freely, voluntarily, knowingly given. State have an announcement on counts 2 and 3.
The state will no count 2 and 3, Your Honor.
Okay, and that's the drive on suspended and the refusal.
That is correct, Your Honor.
All right, just to make sure it's clear, because we have some sequencing issues. All right, on count 1, which is a felony DUI, adjudicates you guilty, 3 years of probation. You can request early termination, but that will be decided by the court at that time. Multi-offender DUI school, $2,000 fine, $551.73 in court costs, 50 hours of community service work, which can be bought out at the statutory rate. Permanent revocation of your driver's license. 2-year ignition interlock device if you ever become eligible for a driver's license and a 90-day impound of any vehicle that you're going to drive. This is a guideline sentence based on the 36.4 points that were scored. Anything that I've missed? Okay. Mr. Sheik?
No, Your Honor.
All right.
Guys, there was a previous capious issue in this case.
I'll withdraw the capias so much as it needs to be withdrawn, not that the case is over with, but since sometimes we're getting a little bit of a lag in the case is being listed as closed, to make sure that the minutes show that the capias has been withdrawn. All right, you've got to meet with probation behind you, Mr. Poche. I need your fingerprints before you leave, then you have 30 days to appeal the judgment and sentence of the court. All right, thank you.
Thank you, Judge.
All right, thank you. All right, Mr. Powell, oh, that's confusing. He was here first? Okay. All right, Mr. Dixie Powell, come on up.
Dixie Dan Powell on behalf of Bobby Wilson, Your Honor. He's approaching. I made kind of a wrong assumption in this case. I thought we had a agreement worked out, but I hadn't talked to Christine about it.
Ms. Basso.
Because the violation of the probation officer had recommended 6 months on the VOP, and we were prepared to admit, but I guess she needs to speak to the victim, so if we could set it for the 28th.
Basso, can I get you to come up to the podium? Last week, I think we had some issues where that microphone over there wasn't picking up Ms. Barrickman at all, even though she was closer to it now than you were, so.
And yes, sir. I did speak briefly with Mr. Powell this morning about this, but this is one where I feel strongly I do need to discuss it with the victim just to be sure there's no objection. So if we could set it for the next available date, we can go ahead and get that done at that time.
All right, it'll be August 28th at 9 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
Or a plea.
Yeah, and I thought we would do it today, and but my bad.
It's all right. I mean, if they have, then the state has certain obligations
Yes,
that
sir,
they
I
have to do
understand.
under Marcy's law. They're going to do that. We'll come back for the plea in a couple of weeks.
Thank you, Your Honor.
All right,
Thank you, Your Honor. See you then.
All right. Other Mr. Powell. Morning.
Alicia Johnson. Hey, Felicia. Hey.
Ms. Johnson is here in 24 CF 2693 and 25 CF 324.
This is on 2693, Judge. Motion for bond.
Okay. And so this bond was revoked based on the new case?
That's correct. She's been in jail, Judge, since about 7 months. And the problem in the case is that you wanted all the attorneys from all the various defendants in this foray here that happened to take the depositions together. We cannot get that done. It's impossible. So I'm going to do it myself. But that's not her fault. Then she shouldn't be punished for that. We need a bond, Judge. She's got kids at home. We're going to bifurcate this case and try this 2693 before Your Honor. Try to get it over with quick. Pending, but we want to bifurcate them. But she needs a bond. There's no reason she shouldn't have a bond. She's got a separate charge, and we understand the policy on that, but, you know, it's been 6 months. At least.
Your Honor, the state objects to reinstating the bond. Ms. Johnson was out on bond on 24 CF 2693 for aggravated assault by threat with a deadly weapon. While she was out on bond, he was rearrested for possession of controlled substance, another felony. There is no change in circumstances. 6 months. I understand about the deposition, but I've shared my availability. They were actually set at one point, and then they were the depositions were continued because the defense attorneys couldn't agree on the time needed to depose all the witnesses.
Are all there's co-defendants, you said?
Yes, there are.
Are they all in my division now?
Yes.
Yes.
And who are those people?
Marcia Reed is the other defendant. I think that's it.
I never get them set, so I'm gonna do my own depositions, if that's okay with you.
Well,
I gotta
if
get it
if people aren't coordinating when you're trying to coordinate, then that's kind of on them. I mean, it sounds like you've made a good faith effort to do so, Mr. Powell.
We have, Judge, and you just can't get it all worked out, but she shouldn't be punished for that, and, you know, 6 or 7 months in jail when she's got kids at home and everybody's dependent on her. I mean, she needs a bond.
You know, if I may, I'm not sure if I understood correctly. The deposition that was continued had been scheduled by Mr. Charles Williams and not Mr. Powell. Mr. Powell never scheduled any deposition.
Was that on the co-defendant?
On the co-defendant, yes, Your Honor.
That's Reed?
She goes by either Knox, K-N-O-X, or Reed, R-E-E-D, or I'm pulling it up, 1 second.
We approach a minute.
Sure.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Fire. Damn thing ain't working. Whoa.
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law.
I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with
All right, in 24 CF 2693, any other arguments regarding the bond motion?
No, Your Honor.
No, Your Honor.
All right, based on the delays in the case because of co-defendants and getting depositions set, I'm going to grant the motion $50,000 cash or professional GPS monitor at $1 per day, no contact with the victim, check in with pretrial services once per week by phone. Also, no possession of any weapons, including firearms. And if you have any of those, they need to be surrendered to the sheriff's office within 72 hours of your release.
Thank you, Judge.
Thank you.
Just the aggravated assault, she already has a bond in 25 CF 324. I'd rather, because it's going to take a while, I'd rather just get through the other cases first.
Thank you, Judge. That's
All right, thank you, Mr. Powell. All right. Who else do we need? Y'all want to get started? Ms. Rivers, Mr. Williams, Mr. Maddox?
Only have 2. Yeah, I'm fine. I'm ready to go.
Maybe 3.
Who do y'all want to line up?
I don't either.
Want to do out of custody? Do you have any? Mr. Maddox?
Checking right now, Your Honor. I don't believe I have any out of custodies today. The only one that's listed for me is Derek Toller, but as we discussed last time, I've withdrawn from that case. That is Mr. Klein's case.
Y'all seen Mr. Klein's? Oh, that's right. That's right. He had said that last time. All right, Mr. Russell, go ahead and call those.
Teresa Edwards. Ms. Edwards is present and approaching, Judge. This is case number 24 CF 2116.
Sorry, can you give that again, Mr. Russell? I wasn't ready for it. It's
Okay.
not on my docket. I know we just had this last week, but.
We did, something like that, Judge.
Yeah.
Her name is Teresa Edwards, and it's case number 24 CF 2116.
What are we doing with Ms. Edwards, please?
So Ms. Edwards was just in court, Judge, on July 24th. At that time, the court found her incompetent to proceed and unrestorable. We did not discuss probation, and then after that hearing, probation contacted me and asked me what's going on, and I said, I don't know what we're doing, so I've set it for today's hearing to get some clarification. I'll let the probation explain what's going on.
I guess what I don't understand, without getting into the facts too much, is how she was able to enter a plea in 2024 when she's in, the reason for her concerns predate that, and she was placed on probation, to which she can't handle it because of the concerns. This is not a situation like someone went on probation, during the course of their probation, suffered some sort of injury that led to them becoming unrestorable. So, were y'all a part of that case back then?
The original case, yes. I
PD
was.
did represent her, Judge, but I believe it was a prior public defender on the case, and I can't speak for him, so.
Have there been any issues since she was released 2 weeks ago? Husband? Edwards, can you come on back up? He can go here is fine, if that's okay, Ms. Leone, with you. All right, Mr. Edwards, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. She's been home for about 2 weeks now?
Yes.
All right, tell us how it's gone.
Very well. Better mood and haven't done any violations.
My understanding is the only terms of condition that she really has is BIP, which I can't imagine she can handle, but also no alcohol or drugs without a valid prescription, and random UAs, which is part of what her release conditions were 2 weeks ago, correct?
I think the issue that probation has, Judge, is that they can't supervise her in her situation. I don't know who would supervise her. Is she on pretrial services? I don't remember.
be bond conditions.
Oh, I agree with
Yeah,
that.
yeah.
I'm just trying to fashion some sort of resolution, because this is kind of a issue of first impression for the court, that someone could plead and not be found incompetent in November, and a couple of months later be found incompetent based on things that happened years ago. It just feels like somebody dropped the ball back last year.
I don't know if she was,
Originally took the plea.
I do not know if she was evaluated originally. I didn't look that far back. We did have 2 evaluations in this case. The second was at the state's insistence, and both Dr. Zeman and McDonald said she was incompetent and unrestorable.
At this point, I don't think probation has to supervise her. She's in a situation where she's in a violation status, so I think probation is told. However, she still has the release conditions, but that's a pretrial supervision issue. Sure. It's 2 more times than me, so.
What we did in that situation is we sent orders to the court basically saying that the department is not responsible for supervising her until A, she's restored to competency, or B, her termination date. So it wouldn't necessarily be told that she's not competent the entire time she's on and not restorable. She would just term on the regular term date. But the VOP was set aside because she can't enter the VOP because
Well, I don't think anyone's moved to set aside the plea. Did you say?
no, set aside the VOP.
Oh.
She can't enter a plea to a VOP if she's incompetent.
I understand that, but I guess the issue is, if she's not competent, how did she willfully violate her probation in the first place?
Well, that's up for
she
debate.
wasn't deemed incompetent back then.
Yes, Your Honor.
So that's that. I think the semantics are important.
Judge,
The court dismissed the VOP.
If this state doesn't object to that, then but then she'd have to go back on probation, which she's going to struggle with.
Yeah.
And there was no evaluation back last year, right? It was before my time in the case, so I'm just trying to.
I'd have to look in the file, Judge. I can't. I wasn't that attorney, so I can't tell you that.
I don't believe so, Your Honor. I don't believe there was any evaluation prior to entering the original plea to the charges.
So, without suggesting what should be done, if the VOP were dismissed and she get put back on probation, the possible motion to set aside the plea, or either a 3800 or a 3850. Which I don't, can the PD file a 3850 on their own?
We can't file one against ourselves, Judge. That would be the problem. The only thing about a competency evaluation is I can't tell you right now whether we did an in-house confidential competency evaluation, because, like I said, I wasn't the attorney back then. I can look through the file if you want to pass it for a few minutes and let me look at it, then I can tell you.
Why don't we do that, and then we'll have to figure out if she's Why don't you do that, and we'll readdress it when Mr. Kleins is back to see what he thinks about potentially their appointment for purposes of whatever needs to be done if the VOP is dismissed.
Yes, sir.
I just don't want to indicate what should be done, but I think just trying to talk out the options because this is something, again, I don't think I've ever seen before in over 20 years of doing this.
Okay, we can do that, Judge.
All right, let's recall
So we'll
it.
pass it for a second, okay?
All right, who else do you have, Mr. Russell?
William Ewing. Mr. Ewing is present and approaching. Case number is 24 CF 569. This case we also had in last week, Judge.
I just see that we're here for statuses. We were waiting on a report. Did that come in?
That's what happened. So on the 31st, Judge, we were here. We were waiting for Dr. Zeman's report, and then it came in Monday. And so that's why I brought it back, because you had set it originally for the 28th.
I just don't think anyone sent me the report.
And it's filed on the new website, and I can give you a copy if you want to look at it.
Why don't you just do that? Otherwise, I'm going to have to look it up 3 different ways.
May I approach, Judge?
Yes, sir, please. Thank you, Mr. Russell. Was the previous one filed?
Yes, sir. I can tell you.
I believe it was in May, Your Honor.
In June. Let me look at my notes here.
I think it was June. Wow.
I think it was filed and sealed June 19th, maybe. Or June 3rd, one or the other.
I think we set it for the 19th, so let me take a look.
I think what happened is I filed it June 3rd. Mr. Ewing had not seen it, so he postponed it till the 19th. He came back. He said he wanted a second eval. That's when the court decided to to appoint Dr. Zeman for a second eval.
All right, so now we've got 2 evaluations. One says not competent, one says competent.
Correct. And so I think normal procedure is to get a third eval. I'm not sure who the third doctor is.
Assuming it's going to be one of those out of the area doctors who do them over Zoom.
Do you want me to submit an order in the court of fill in the blank?
Yes, I just have to get with court admin to see who's currently taking those.
We can do that. Do you still want to leave Mr. Ewing set for status on 8/28 just as a control?
I think we should. I don't think much is going to get resolved by then, but just to make sure that it's moving forward.
Okay.
If you could send me the order, leave the name of the doctor blank, and then we'll check in with who's currently doing them. There's some people in Central Florida, I think, who do them over Zoom, and we have to have a third one because we don't have enough providers up here.
Right, okay. So next court date is 8/28 at 2 o'clock, okay?
So I have to be here?
Yes, sir. But sir, you're going to have to do a third evaluation. Yes. That's probably going to be done on Zoom. Have you ever used Zoom before?
Yes, sir.
Okay. Just to, if you're not, I was going to say familiarize yourself with it so you can get that done more quickly and we can resolve your case. All right, August 28th at 2 o'clock. Mr. Russell, you're to provide an order.
Yes, sir, and as soon as I get...
that I'll add a name to once I get it.
And as soon as I get that, then I'll pass that on to Mr. Ewing and they can set up the Zoom meeting.
All right, thank you, Mr. Ewing.
Thank you, Your Honor.
That's all my out of custody, Judge.
Your Honor, I did have, and looking back over the docket, the 3 where you signed orders for last night, Alford, Hard, and Brofton. Do those need to be addressed with the court, or is that?
I don't think they need to be addressed.
Okay.
I bristled a little bit about calling it a sentencing error, but whatever gets it fixed. It's just something I failed to say revoke in term. Just, and I think in the future, just make sure we put that on the plea and sentencing agreement so it's clear. What do you have? Beckham?
Judge, this is Lori Beckham. Case number for the record is 24 CF 2185. This is the case that we had a competency hearing back in February 26. Court found her incompetent to proceed, ordered her to the state hospital, and then the court set the status or control date to today. I have contacted the people at DCF to see where she is on the wait list. They could not tell me how long before she got picked up. They did tell me that she is number 23 on the wait list. My understanding is that females are more difficult to get sent to the state hospital because they have fewer facilities. And then Ms. Beckham has asked me to ask the court. She wants a second evaluation, and I told her I would bring that up, but I don't know if the court will do that since you've already made a decision.
Just to make sure it's clear. By order, at least, she was judged incompetent to proceed back in early April, over 4 months ago. And the Department of Children and Families has yet to come pick her up so she can get restoration treatment.
That is correct, Judge.
You know what day her first, I guess, only evaluation was filed?
When it was filed with the court, Judge?
Yes.
It looks like it was filed on 2/26. That's my file, shows that that's when we had the hearing.
That's when we had the hearing, but I don't see it in the file.
I filed and sealed. Did you check?
I'm showing an exhibit inventory that shows that it was filed on that date, and to be sealed, apparently sealed means I can't see it anymore either.
Do you want to see the report?
If you've got it handy. Yes. Can y'all approach?
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Ms. Beckham, what I'm going to do is I'm looking into the issue. Mr. Russell's going to look back into it to see if they can give you a timetable, but we're going to readdress it at my next possible court date, which is unfortunately 2 weeks from today. But if I get some new information, either through my own looking into it or from Mr. Russell, we may address it without having another hearing, at least so we can have some sort of game plan, because waiting around for 4 months is unacceptable. So, and I've had these issues with other state agencies that we're not supposed to be holding people in jail when they're supposed to be in treatment centers. It's just not how it's supposed to work. But I want to make sure that you get the restoration treatment that you need, the counseling. But I've got to do it in a way that's safe.
Yes, sir, I understand.
Okay.
Yeah, I don't want to like leave and be on the streets.
That's what
I
I'm
understand that.
I'm hoping to avoid, and unfortunately, there's not really much I can have the jail do to help you out to get ready for the release, because they don't have any sort of services that can be
Programs, right.
provided or programs.
I have been writing places on my own accord too, so.
Well, I'm sure we could find a place that would be beneficial to you personally, but unfortunately, those places can't do the particular set of treatment or counseling that we have to do for the purpose of the case.
Okay.
And that's the issue. So I'm going to put you on my pretrial detention docket on August 21st at 12:30. Actually, that's not even really usually a date we put stuff like this on, but I wanted to do it as quickly as I possibly can instead of putting it out yet another week. So August 21st at 12:30, we'll address it at that point. But again, if I get new information before that, I'll certainly try to get something done. All right, thank you.
Your Honor, this is Mindy Raven Taylor before the court on 24 CF 2003, 24 CF 2004. We've reached agreement in this matter. If I may approach.
Ms. Taylor, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
All right. Can you state your full name and date of birth, please?
Mindy Raven Taylor, 6/11/91.
All right. And Ms. Taylor, you're here in two cases on violations of probation, 24 CF 2003 and 2004. I've been handing a plea and sentencing agreement that calls for you to admit your violation of probation. It would revoke and terminate your probation in both cases. In 24 CF 2003, count 2, which was a misdemeanor, it'd just be credit for time served. On the other 3 counts, it would be 12.1 months Department of Corrections with credit for time served, $100 cost of prosecution for each case, so that'd be $200 total, $100 PD fee for each, so $200 there, and a one-time $50 application fee. Is that the agreement that you've made?
Yes, sir.
Is it the state's agreement?
Yes, Your Honor.
All right. Did probation get all that? So it'll be a revoking term and just DOC? Okay. What about any outstanding monies owed? Just set it to judgment? Okay. All right. Is that what you want to do, Ms. Taylor?
Yes, sir.
All right. I show she doesn't score, but this is a 12.1.
Yes, sir.
All right, Ms. Taylor, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
And are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your admission to the violation of probation?
No, sir.
And do you understand that by making an admission to a violation of probation, there won't be a evidentiary hearing where the state would have to prove that you violated your probation? You understand you're giving up that right?
Yep.
What was that?
Yes, sir.
Yes, okay. Sometimes the microphones don't pick it up when it's a quick answer like that. I want to make sure I heard you. All right. And this would be an adjudication of guilt, obviously, because it's a 12.1-month DOC sentence. Do you understand you're waiving all potential defenses you have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea to the 2 violations of probation in 24 CF 2003 and 2004?
Admission.
Okay. I'm going to accept your admission as freely, voluntarily, knowingly given. In 24 CF 2003 count 2, it's going to be credit for time served. In the other 3 counts, it's going to be revoke and terminate your probation, 12.1 months DOC with credit for time served, a $100 cost of prosecution per case, $100 PD fee per case, and in 24 CF 2003, the $50 application fee, be an adjudication of guilt. Revoke and terminate probation. I want to say that again just to make sure, because I missed it a couple times last week to say that. Anything that I've missed? Yeah, DOC would be concurrent between the 2 cases and all costs to judgment.
Thank you.
All right. Do you need fingerprints for her? I think she was, already had them. Okay, I thought so. All right, you have 30 days to appeal, man.
Your Honor, this is Joseph Thompson before the court on 24 CF 2424 on our motion to reduce his bonds. He is before the court on 25, I think it's 25 counts, 30 counts, and bond was set at $25,000 cash or professional on each count for a total of $750,000. Mr. Thompson has been in custody since October 15th. He's unable to post such high bonds. He's asking the court to reduce his bonds to $1,000 per count. Mr. Thompson has no criminal history. He's lived in Okaloosa County the majority of his life. He has ties, family ties to the community. He's asking the court to reduce his bond.
All right, Ms. Basso,
Your Honor, the state believes, given the totality of the circumstances, that the $25,000 cash professional per count is appropriate. Mr. Thompson was found to have over 100 images involving child pornography that included children as young as infants and toddlers and bondage taking place. Therefore, we do believe that he does pose a threat to the community and that the bond is appropriate. If the court does wish to enter a bond, the state does request that we have at least the conditions of pretrial services, a GPS monitor, and no contact whatsoever with any minors, and also no access whatsoever to the internet.
And, Your Honor, he has no objection to that.
I understand that there's already a bond. It's just
Yes,
a
Your Honor.
reduction of it.
And I just wanted to be sure we didn't miss any of those conditions. And Your Honor, he
Status
does.
of the case, if it's been around since October, where are we at in a potential resolution,
Your Honor,
trial?
Your Honor, Mr. Zawicki was scheduled to come out. He is our expert that we have retained. He was scheduled to come out on the 31st or the 29th of July. He got detained in Atlanta. There was a problem with the flight. He was unable to make it. So
Delayed, maybe we would say.
Sorry, yes, delayed. And
Detained sound like he's under arrest.
no, Your Honor.
Okay.
And the matter has been reset for later in August.
Your Honor, I would like to add also that given what he does score out as a minimum guideline, we do believe that that might also make him a flight risk because he does score out to 558 points, which is a minimum guideline of 397 months and up to 450 years.
But he does have family ties to the community, and he has no prior criminal history.
I mean, I'm hearing that in the kind of, you're telling me he has connections, but I haven't heard anything about what they actually are.
Your Honor, if we could take testimony.
Mr. Thompson, raise your right hand. Right hand, please. Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
Would you please state your name for the record?
Joseph Thompson.
Mr. Thompson, do you reside here in Okaloosa County?
I do.
Do you have any family that resides here in Okaloosa County?
Most of my family.
Okay. Could you tell the court some of the family? Like, does your mother reside here?
My mother lives in Pensacola, but my father lives here in Baker, and I live with my uncle on our family farm that's been in the family for multiple generations.
Is that in Baker?
That is in Baker, yes.
And do you have a passport?
I do, but I would surrender it.
Thank you.
All right, based on my reading of the court file and arguments made, based on the evidence that it seems to be that Mr. Thompson is involved in this issue, I'm going to deny the motion to reduce bond. There's certainly concerns with what I've read as far as the allegations in this case that Mr. Thompson is a danger to the community, also based on the fact that he scores over 500 points on a presumptive score sheet, that he has a reason to flee. Obviously, I'd like to get the case resolved. I understand there was an issue with the expert that's coming down to review the evidence, but I've got some pretty serious concerns about what I know about the case. I think the bonds are adequate where they're at.
Yes, Your Honor.
Thank you.
Your Honor, if I may.
Yes.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
All right, do you have anyone else, Ms. Rivers? You can wind up. Russell?
Judge, he's going to need a hearing aid if we can.
Oh, okay. I apologize.
Yeah, now.
Can you hear me? Can you hear me? How about now? Okay. Charles Russell, Public Defender's Office. Judge, this is Herbert Atkins. Case number is 2007 CF 622. Mr. Atkins is here on a VOP. At this time, we're going to enter denial on the VOP. Ask that it be set for August 28th at 2. No subpoenas, so they can meet with Mr. Atkins and figure out how we're going to proceed.
It looks like y'all were appointed relatively recently, but he also had filed a petition for writ of habeas corpus back on July 23rd, if you've seen that, Mr. Russell.
I have seen it, Judge, and that's one of the things I'm going to talk to him about.
As to whether or not you're going to adopt that petition on his behalf.
Yes, sir. That's one issue.
All right, so you want the 28th at 9 o'clock?
Our schedule doesn't show that you have a 9 o'clock.
I think we've already been putting things there.
And that's what I was going to ask.
I think the updated master calendar shows that, and I'm doing this going forward, is any morning that I have miscellaneous in the afternoon, with arraignments on those Thursdays, we're just going to do the 9 o'clock docket as well. Otherwise, we don't have enough time to get all the hearings done that we need to get done. But if you'd rather have it at 2 o'clock, I can certainly do that as well, Mr. Russell.
Yeah, we just set Mr. Ewing for 2 o'clock, so why don't we set Mr. Atkin for 2, and then I can just be here at 2.
Okay. August 28th at 2 o'clock.
Sure, Mr. Russell, was that with or without subpoenas?
Without.
Your Honor, this is Mr. Lynn Banks before the court in 22 CF 2873. Your Honor, one to denial at this time. For now, I'll set it without subpoenas for the next court date.
Without?
Yes, Your Honor.
Ms. Leone, is this one yours? Banks?
It's mine.
Oh, it's yours. Okay. Go August 28th at 9 o'clock without subpoenas.
Sure, that's fine, Your Honor. Thank you. Your Honor, that's all I have for this, but out of an abundance of caution, I did see for George Brofton that you submitted or signed the order in case.
I signed all 3 cases, Brofton, Ard, and
Alfred.
Alfred.
Yeah, he had 2 case numbers. I saw one order for 2580. I just wanted to make sure you signed the other one, just to avoid any sort
I
of.
assume they all got signed because I've signed them all together.
Okay.
I'll double check.
I do have it in case not.
But the revoke and terminate. Pretty sure I signed 4 of them yesterday.
Okay, then we're good.
So maybe
I
just
saw
haven't
3
received
that came back through the email. I just wanted to make sure nothing gets lost. Thank you, Your Honor.
What about Tolar?
Solar we conflicted off that case, Your Honor. That's now Mr. Klein's, I do believe.
Okay. Well, let's just see who we've got. I just wanted to make sure because it's under your name.
Certainly.
Who do you have? Mr. Williams, Mr. Durham.
That's mine, Your Honor. Judge, this matter is currently set for jury selection and trial it's set for jury review today, but the trial week would be August 18th. Mr. Durham has made yet another counteroffer to the state. The state, I think, is inclined with a modification to accept that, but needs to run it past the victim. Can we reset this for next Thursday's pretrial detention hearings? I know I'm going to have them that day anyway.
My only issue is, I think I brought this up already, is I have a civil jury trial next week that's supposed to go through Thursday. So if it's going to be a plea and relatively quick, I think we can handle that. But we can't have any contested evidentiary type hearings that day because, frankly, I'll be in the middle of a trial when I take my break. So that basically turns my entire lunch break into working on other cases, which half of it will already be that. So
Since I'm going to be doing pretrial detentions next week anyway, what's the court's intention if we get any?
we'll have them at 12:30 like normal. I'll just have to kind of work my trial around that. Hopefully, I'll know better in advance. But that's kind of the problem with how we've got it set up, that they're every Thursday with every assigned judge, which works for the most part, but every once in a while it causes problems like this. So we can put it on for 12:30 if you've worked it out. Just do a notice of hearing for 12:30 next week, Thursday.
Yes, sir.
That's fine, Judge.
As long as, again, it's a resolution and it's not going to be more than your average.
Yes, sir.
Receipt of a plea.
Yes, Your Honor, we wouldn't.
Otherwise, we're going to be set for August 18th for purposes of jury trial.
Yes.
Yes.
8:30.
Yes, Your Honor.
And
All right.
since you want to do, are we talking about doing a pick and go, starting on Tuesday? You want to go ahead and handle that part of it now, just in case?
The number of jurors is that you think you might need as well.
I would ask for at least 50, Your Honor, because of the amount of strikes that each has, which is 10.
That's fine, Judge. We should be able to do it
Do you
in
think
that.
is enough?
Yes.
I don't think we've got anywhere near through 50 recently, so I think that would be sufficient.
Yes, Your Honor, and I would rather pick the jury, argue any motions in limine on Monday, and then start trial Tuesday morning.
That's fine with me, Judge.
I'd really like to know if there are going to be any motions filed, so I can prepare for those.
Yes, Your Honor, absolutely. I don't think I have really any, other than the standard.
Standard
Yeah,
boilerplate stuff. Okay. If there's anything that's not standard,
Yes, Your
let's
Honor.
make
I
sure
would
we get
be-
to it.
Yes, sure to file it.
All right. We'll see either next Thursday or the following Monday, Mr. Durham, depending on what they work out.
Thank you.
All right, thank you.
May I be excused?
Yes, sir. We'll see you later. At 1:30?
Be back for pretrial detention.
Oh, you'll be back for those, okay. Is the state going forward on other the pretrial detentions, do y'all know?
No, Your Honor, they're going to be bond hearings.
I know they were just from yesterday, right?
Yes, we were scrambling, but we got together.
Judge, if I can approach.
I had to watch first appearance on video this morning from yesterday to find out what they even were, so.
This is State of Florida versus Nathaniel Jones, 4624 CF. This is the case where the court rejected the plea because Mr. Seek was standing in for Ms. Leone, and there was no certainty as whether or not the victim had been spoken to. My understanding is that the victim has been spoken to, and in
I
fact...
think my concern was whether or not, correct me if I'm wrong, is that there was concerns that he had been in contact with the victim.
That's the basis for the violation, Judge, but the victim had contacted our office several times, seeking to have contact with him. And my understanding is that the state has talked with the victim and that...
Since the last time we were here?
Yes, Your Honor.
Yes, sir.
Okay, why don't you tell me about that then, Ms. Leone? My concerns, not that there was an allegation of it, but my concern was what I heard last time was I needed to make sure there was no potential coercion or anything like that as to why the victim in the case wanted contact.
Yes, Your Honor, you spoke.
Yes, Your Honor. So I spoke to her afterwards, outside, away from everyone else, so there was no possible coercion or anything that was going on, Your Honor. I spoke with her. The original plea had said in it that there was contact was allowed if requested by the victim. And speaking with her, she's adamantly said that she screwed up in going to probation to try and get that permission, or to give that permission. They went together, and that was where the mistake happened, Your Honor. And she did assert that she definitely wants to have it just changed to no violent contact, Your Honor.
Okay. And that was after the hearing that we had?
That was after, yes, Your Honor.
All right, so what I've got is on the VOP in 24 CF 1683, upon admission of the violation of probation, revoke in term, adjudication of guilt, 2 years community control, reimpose the previous requirements of probation, cost of prosecution of $100, $150 for PD fees, and no contact with, I'm sorry, no violent contact with the victim.
Yes, sir.
I'm just trying to find what the previous conditions were. Yes, sir. ECLC or similar, which I think would be the ECLC, right?
It would.
I think it says ECLC or similar for substance/alcohol abuse.
Yes, sir.
Has there been any movement on restitution? It says reserve 90 days for restitution. I guess we're past that date. Y'all have anything about restitution?
No, I don't have information.
Okay. Mr. Jones, is that your understanding of your agreement with the state? Is that what you want to do today? All right. Raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your full name and date of birth, please? Mr. Williams, can you just move the microphone a little more towards him? You can put your hand down, Mr. Jones. I can hear you. I just want to make sure it's picking it up. All right, we're here in 24 CF 1683, which is a violation of probation on a second-degree felony. So there's a maximum incarceration of 15 years. I've been handed a plea agreement that calls for you to admit your violation of probation. The court would revoke and terminate your probation, adjudicate you guilty, sentence you to 2 years community control, reimpose your existing requirements, which again are battered intervention program and the Emerald Coast Life Center or similar program for substance and alcohol abuse, and then no violent contact with the victim, $150 PD fee and application, and $100 cost of prosecution. Is that your understanding of the agreement?
Yes.
Is that what you want to do here today?
Yes.
Is that the state's agreement?
Yes, Your Honor.
All right. Have you gone over this agreement with your lawyer, Mr. Williams?
Have you gone over?
All right. With your lawyer, comma, Mr. Williams?
Oh, yes, sir.
Okay. And did you understand the agreement?
Yes, sir.
Did you sign the agreement?
Yes.
And there were some changes here where it turned to about the no violent contact, and you've initialed here, is that correct? Okay. And are you satisfied with your attorney's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
And this would be a downward departure.
Is it a revocation and termination, Your Honor?
It's a revocation and termination.
Then it is by agreement of the party and need for treatment.
And are you currently suffering from any mental health issues, Mr. Jones?
No.
You understand, I'm sorry, has anyone forced, pressured, or threatened you in any way?
No, sir.
To enter this plea? Has anyone promised you anything in return for your admission? Do you understand by entering the admission that there wouldn't be an evidentiary hearing where the state would have to prove your violations of probation?
Yes, sir.
And do you understand you're waiving any potential defenses that you may have to that violation?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes.
And what is your plea to the violation of probation? Are you admitting or denying?
Admitting.
I'm going to accept your admission as freely, voluntarily, knowingly given. This would be an adjudication of guilt. You formerly had a withhold of adjudication. So this would now be a felony conviction. Do you understand that?
Yes.
And from my reading of the previous plea and sentencing agreement that put him on probation, this was to attempted aggravated battery. Is that right?
Yes, Your Honor.
Would that still have made this a second-degree felony?
That should make it a third-degree felony because attempts are 1 degree under.
I agree. I'm just for purposes of the amount of probation and exposure if there's a violation.
Need to check the information, Your Honor.
All right.
That it's an F1. If that is the case, this will be a second-degree felony.
That's what I'm just trying to make sure that's getting figured out because there's no statute number on here.
Yes.
Judge, the original charge was aggravated battery with great bodily harm under 784.045 sub 1A1 and 2, which was listed as a second-degree felony, level 7 offense on the original charging document.
Well, on the amended information from August 12th.
That's what I'm looking at. Yes, sir.
An F2L7.
So it would be a third-degree felony, Your Honor.
It's a third-degree felony. Well, it changes things as far as the amount of probation or supervision he can get, plus if he were to violate, how much time he could ultimately get. Again, I still don't understand the factual basis for an attempted aggravated battery with great bodily harm, but that's what the plea was entered previously. All right. So it'll be, again, a revoke and terminate of probation, adjudication of guilt, 2 years community control on a new supervision, reimpose the existing requirements, which again were batter's intervention and ECLC or a similar program for substance or alcohol abuse, no violent contact with the victim, $100 cost of prosecution, $100 PD fee. Again, this was a downward departure based on the uncoerced plea bargain with the state, as well as the need for treatment, is what I was told. Otherwise, he scores 29 months.
Yes, sir.
All right. Mr. Jones, I'm going to need you to talk to probation, who's standing and has something else. Cost of supervision will be waived due to the fact that he's indigent and represented by the public defender. All right, talk to probation. I need you to be fingerprinted because it's an adjudication of guilt at this time, and 30 days to appeal.
Thank you, Judge.
Thank you.
Judge, this is Randall J. Odom, case numbers 4623 CF 730 and 4623 CF 1947. We're actually here for a bond hearing. I don't recall if the court, when we were in court last week, if the court just passed the case until today or took the denial and set it for a later date. My file seems to reflect that it was just set for today. So we would still need to arraign him on the VOP. I'm trying to decide whether.
All right, I'm looking at the minute sheet from last time. There was a denial was already entered, and it was just set for a bond hearing today.
Judge, it looks like we've got the case resolved, though. Is this what you want to do, is the 30 months that you just counteroffered?
Yes, sir.
Okay. Have we previously gone over what your rights are on a VOP? Did I go over that with you yesterday afternoon?
Yes, sir, you did.
Okay. Let me get your signature up here then. Yeah, I know it's a pain in the butt. You mind if I date it for you?
No, sir.
Madam Prosecutor. Judge, this will be a slight downward departure by 1.25 months, I believe. It'd be based on a legitimate uncoerced plea agreement.
The guideline was 31.125 months. It's going to be 30 months.
Yes, Your Honor,
So
if the court agrees.
It's only about 5 weeks difference. right. They're both VOPs, right, Mr. Williams?
Yes.
I'm sorry, Judge, yes, sir.
They're both VOPs?
Yes, sir.
You have 730 as a VOP with what the charge was, but you didn't put VOP next to the felony battery. I just wanted to make sure I've got it right. I looked it up just to make sure, but.
I checked the file. He was previously sentenced on it, so they're both VOPs.
Okay. All right, Mr. Odom, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
Can you state your full name and date of birth, please?
Randall Jackson Odom, March 1st, 1959.
All right, Mr. Odom, you're here in 23 CF 730, which is a VOP on a second-degree felony, punishable up to 15 years in state prison, as well as a VOP on a felony battery charge, and 23 CF 1947, which is punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea agreement between you and the state that calls for you to admit your violation of probation, revoke and terminate your probation, adjudicate you guilty, sentence you to 30 months in the Department of Corrections, concurrent from each case, $100 cost of prosecution, $150 PD fees. Is that what you want to do today?
Yes, sir.
All right. And have you gone over this plea agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Are you currently suffering from any mental health issues?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea? You understand by admitting your violation of probation, there won't be an evidentiary hearing where the state would have to prove those things against you.
Yes, sir.
You understand that you're waiving any potential defenses that you may have.
Yes, sir.
I didn't notice it was mentioned here about credit for time served.
Well, Judge, I think he's automatically entitled to credit
But-
for all time
yes.
served, so.
I think if I don't say it, I may end up getting an email with it, can you correct this? So I just want to make sure it's
All right,
clear.
Judge, yes, sir, it's credit for time served. Mike,
All right. And do you understand if you're not a U.S. citizen, Mr. Odom, this could lead to your deportation?
Sir.
You understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And Mr. Odom, what is your plea to the 2 violations of probation? Are you admitting or denying those?
are you admitting the violation of probation for this sentence?
Yes.
I'll accept your admission as freely, voluntarily, and knowingly given. I'm going to adjudicate you guilty on both cases, revoke and terminate your previous probation, sentence you to 30 months in the Department of Corrections, which is a downward departure of about a month and a half, based on the uncoerced plea bargain between the defendant and the state. That will be concurrent between the 2 cases, $100 of cost of prosecution for each case, and a total of shouldn't it be 150? For PD fees, it's 100 per case, and then 50 for the application?
Yes, sir.
Okay.
Yes, sir.
So 100 PD fee for each case, $50 application fee. I'm going to send all those to judgment. Anything that I've missed?
No, Your Honor.
No, Your Honor.
All right, Mr. Odom, you've got 30 days to appeal. Good luck.
Thank you, Judge. Judge, I believe that's all that I have this morning.
Okay, Mr. Russell, did you have a chance to talk to Mr. Kleins about Miss Edwards? And okay. Well, I think he's talking to him now. What about Huggins?
I don't know.
I believe Mr. Johnson is present.
Oh, Mr. Johnson? Is that you back there? Come on up. Yeah, sorry. Usually the private attorneys sit in the first row, so I know who to call, but I was just going through the docket and see who I hadn't called yet, and I saw you were on here. All right, so let's take this. Edwin Huggins, 24 CF 2652. I think we're here for a motion to compel, but I saw some things were just provided over the past week or so.
Exactly, Your Honor, and I was going to go ahead and bring that up to the court, as I know that there's some issues with the clerk's sites. We did provide yesterday afternoon to Mr. Johnson's office a courtesy copy of the filing of the two of the things that he was requesting. One is the UC consent form from Marivelle Meister, which does identify, it provides the UC consent form that he requested, and it also provides the identity of the individual in the photos, because that is the individual that signed that form. We also provided the UC profile. It was previously provided to the defense in discovery. I confirmed with the individual that was acting as a chatter investigator, Rowell, that that is the full profile. If the defense believes there's anything that's missing, we would need to be advised of what it is, because he has told me that is the full profile. And that is where we stand as to what is provided recently.
Mr. Johnson.
Judge, the profile contains the interests of the person in anime, and that's the first thing they start talking about is anime, and that part of the profile is not in the discovery. But it is not the full profile that was published on the internet.
Your Honor, as I said, I verified with Investigator Rowell as recently as yesterday that this was the full profile. What I did is I actually sent him a shot of what we provided. Said, is this the full profile? If anything's missing, please advise. And he said it was the full profile. That is all I can provide to the court at this point.
Judge, I don't believe the profile, and I have a copy of it here, is in the court file. But the profile was...
Is this the 18-page exhibit that was filed on the first?
Pardon?
There was well, it's listed as defendant's exhibit. I'm not sure if that's accurate, but...
It's in my second motion. The profile they posted was a person alleged to be Laney Luna. And I have the profile here. It says she's 37 years old, Crestview student, high school woman. There's nothing about anime. The first part of their conversation, he speaks to her and says, "Hey, Laney, how are you?" He just finished a long drive. Then he says, "What anime do you like?"
Okay.
And so there's been no previous anime. The way he knows about anime is the profile that was posted.
So he asked about anime. What do you think is they have to turn over to you at this point?
The part of the profile that lists her interests.
Okay.
And among those interests was anime. I mean, this profile is not the profile that was posted and accessible on the internet.
How do I know that other than
How
what
do you
his?
know that?
How do we know that other than that's his initial?
Well, just from my
Text message to her.
conversations with Mr. Huggins, but how would he know to ask her about the question, what type of anime do you like? Because that was listed as one of her interests.
Basso?
Your Honor, again, all I can tell the court is I have a copy of the profile that was provided to the defense. It's the same thing that I showed to the chatter. The chatter indicated that is the full profile. That is all I can represent to the court.
And this is the one that says student, high school, and 37 years old?
Yes, sir, and then it says, not looking, wants to date, but nothing serious, interested in men for dating.
It's the one that's part of the motion.
Correct. That's what like I said, is recently, I wanted to double check and make sure, because there are a lot of different chats that go on with these chatters, so I did take a shot of that, send it to him yesterday afternoon, said, hey, is this everything? And he did confirm to me that it was. And that's all I could tell the court.
What's not listed are her interests under the profile.
It's actually the last line on here. Wants to date, but nothing serious, interested in men for dating.
And the line under profile, which I guess you have to click on, is just a dark line.
Again,
Mr.
I mean, they're
Huggins
saying
says
they've
that-
turned over everything.
Well, according to Mr. Huggins, they did not. And according to the conversations, I mean, how would he, out of the blue, ask her about what kind of anime she likes?
I don't know. Maybe that, well.
I can't speak to what is in his mind, Mr. Johnson. I'll tell you what my
And
investigator.
what was the response?
Responded Black Clover, Seven Deadly, and AOT, which I can't tell the court what
And
that
then
is.
there were further conversations past that, all about the type of anime that she liked.
Is there a way to get some sort of history of a profile on, and this is just like a dating site, it's not like a chat room, right?
It's a Plenty of Fish. So I
It
don't.
is an adult dating website.
Okay.
The name of it was Plenty of Fish.
Okay. But that's what I'm saying, so there's no other communication that's going on between the two or other people or anything like that?
Your Honor, we're not aware of anything additional other than what we provided.
Is there a way to get the history of what the profile said?
I can inquire. I don't believe so, especially since this is back in time. A lot of those, they wipe out once the profiles are taken down. But I certainly can inquire, but I do not believe so.
And I can also check with the web developer, Your Honor.
I think that's the issue, because it sounds like maybe there possibly could have been something more than that, but nobody knows other than.
He says one thing, they say something else.
I mean, that's what adversarial systems turn into most of the time, right? But if they tell you they've filed everything, or they've given you everything, I guess you can certainly file something based on that. But I think I would need some sort of concrete proof that there was something more that they haven't turned over specifically, and how we know that.
I'll try to talk to the host to see if there's anything that still exists, and Ms. Paso can, and then we can talk, and we'll have to see if we have to bring something back to you.
I mean, I think we see plenty of cases where there's search warrants and things like that that go into people's profiles, and I just don't know with this particular site.
Well, we're certainly willing to
if they're able
discuss
to
it.
do that. If they can, obviously they should get it, especially if it's different than what was seen at the time. But I just don't know if it doesn't still exist, what can be done. If there's some sort of spoliation of evidence, I don't know. I'm not just suggesting that there is, but if they say this is everything and you think it's still not, file your corresponding motion, I guess.
I'll talk to them, Your Honor.
Okay. But as far as the motion to compel, they've turned over everything. Let's see if y'all can figure out if there's something else there that they don't have their hands on.
That's the second part. I did get notice yesterday that she filed an amended discovery. I asked for the profile and the consent forms, I think, back in April of this year. And the amended discovery is posted on the website, on a document in the portal. The consent form is not in the portal yet. All the documents that were in the portal were the amended discovery. So I don't know what's there and where it meets the requirements of the standards, but
Your Honor,
I did get notice that she sent something yesterday.
Your Honor, it should have been attached with the filing, and I believe a courtesy copy was sent to your office. I can certainly hand you a copy of it right now if you like. Court needs one.
So you're just talking about what is listed in the first amended discovery exhibit that was filed yesterday?
We
Yes.
listed the UC consent form. It would have been attached, and I believe it was sent directly to Mr. Johnson's office as well.
It would have been attached and sent to Mr. Johnson, but it's not filed in the court file, typically.
Correct. You're right. Correct.
The documents usually aren't, and we get those through the clerk's portal.
I don't think that's accurate. Normally, a discovery exhibit lists things, but those things aren't filed in the court file. They're just sent over to whoever's
That's what
requesting.
I'm saying. But the thing, no, they actually are, the documents, supposedly this was filed in the portal. It's not attached to it, I don't think it's in the court file. If it is, I did not see it.
But I believe we sent it directly to your office
That's
as
what
well.
Well,
Actual
I
ex-
haven't
We have a
received it, but Anyway, I have this.
Actual exhibits don't get filed in the court file.
No.
Just the discovery exhibit itself that lists what's being sent to you individually.
We get I got recordings, videos and things in the portal in this case. It's not in the court file.
You
We're
might be
talking
talking about
about
like an evidence.com portal, which is separate than the clerk's or court's portal. So it may be coming that way. But videos and things, I mean, there's no way to put a video into the clerk system where you could pull it up from that.
But I have not received this document. I'll look at it and see if it meets the requirement of the standards.
Okay. We'll just take a look at it. It may have been sent to your office via an email. I mean, that was always my recollection of it. The email gets sent over with a link you click that brings you to the evidence.com or whatever, and you download everything. You just have to make sure you do it quickly, because I think it expires in 30 days. I've had that problem back in the past, but
Right.
so make sure you get that done right away if that email's been sent over with everything. But otherwise, I think she just gave you a hard copy of it, right?
Yes, sir, and that also lists the individual in the photos, so that you have the name, and that was also provided in that discovery.
The name is listed in the amended discovery exhibit.
That's the actual
It also
form.
says that the consent form is being provided. I just haven't seen it yet until she gave it to me.
Well, I'm looking at it says discovery provided via Stack portal, and they check the box yes. So the portal you may be talking about, maybe the state attorney's office portal, which is Stack.
We normally go to the portal that's part of the clerk's office, but at any rate, it's not there, and we haven't got any evidence link, but we can resolve that.
Okay. I just don't think actual exhibits, actual documents that are being provided go through the clerk's portal. It's just the discovery exhibit that gets filed to the state. Here's what we're providing to you separately. Otherwise, every exhibit would be in the court file, and anybody can just go looking at them, which is not how it works.
I understand.
And maybe things are different in a different county, but that's my recollection across the 3 counties I've been on the bench in my previous work as an attorney in the criminal justice system. So I think they've given it to you by hand, but also they claim they've emailed it to you.
I believe she did.
Okay, let me just double check if there's something you're missing.
I will, Your Honor.
All right.
Also filed a motion to get an unredacted copy of the ICAC standards for 2023. I got a copy.
When was that motion filed?
Excuse me?
When was that motion filed?
June 19th, 2025.
Okay. Have y'all talked about that?
Your Honor, this has come up previously. The ICAC standards are not something that even the state is allowed to have. We've reviewed them, but they are DOJ policy. They are not releasable. Only the redacted version of it is releasable, and that was provided, I believe, by the ICAC commander, according to Mr. Johnson. Our understanding is that, like I said, we do not have access to it. We cannot provide it. If Mr. Johnson wishes to review those standards or get additional access to them, he would need to contact the ICAC commander directly, and that's Mr. Chris King.
Have you attempted to do that, Mr. Johnson?
Judge, what happened is I asked Ms. Basso for the standards. She claimed they were confidential and she couldn't provide them. I did talk to Sergeant King. He's the director of the North Florida ICAT Task Force. He's a sergeant with the Gainesville PD. He sent me what I have attached to my motion as Exhibit 1. And it includes all the ICAT standards except the investigative standards in Section 8, I think. Section 8 deals with the investigative standards. These standards were passed pursuant to a federal law.
Let me just make sure, because you filed a motion, but you filed the ICAC Task Force Program Operational and Investigative Standards as a separate exhibit, correct?
Yes.
What section are you talking about now, 8?
The first motion attached the redacted 2023 standards. And the only thing really redacted is a portion of Section 8.
8.6, 7, 8, 9, and 9.1.
Pardon?
I'm looking at it.
Okay.
Okay.
That is what Sergeant King sent me. These standards are promulgated pursuant to federal law, which is 34 U.S.C. 21, 112, 13, and 14.
All right, give me that again. 34 U.S.C.
34 U.S.C. 2112 establishes the task force program. (3113) talks about the purpose of the task force. 2114 talks about the duties and the function of the task force. And under that subsection, it says that establish investigative and prosecution standards which they shall use and comply with. That's actually in Section 7 of 21.114. So by federal law, they're required to comply with the standards that they...
Are you sure about that? I'm trying to find 34 U.S.C. 2112, and I'm not getting anything.
It's 21.112.
21.112.
I actually have a typed copy too.
Look here. It was my understanding that the motion to compel discovery was set for today. I didn't realize there was anything else that was set.
Well, actually, the first motion was set. We called to try to set the second one and wasn't able to get a response. And then I did receive the amended discovery response yesterday afternoon.
All right. You have a copy of the U.S. Code that you're referring to?
Yes, Your Honor, may I approach?
Okay. Yes, it's not, I mean, it's not cited in your motion. And when I try to pull it up, I can't, it's not pulling up for me.
Really, Your Honor, regardless of what the code says, we do not have it and cannot provide it. It has to come from ICAC.
Well, if the court enters an order, I guess we can get it from ICAT. But the section...
You want me to issue an order to who?
Pardon?
An order telling who to provide it?
Well,
Who's
I
in
assume
possession
you tell the
with?
state to provide it since they're pursuing this prosecution pursuant to the ICAC standards?
We are not
And
citing the ICAC standards as part of our prosecution. That's not required under the statute. So again, it would have to come from the ICAC agency, the
Judge,
ICAC commander.
the standards say, the statute says they had to comply with the standards established.
Statute does not read that, sir. That's the federal statute. This is not, we're prosecuting under a state statute.
This task force is established pursuant to federal statute. They get their money from the federal government. It's a joint effort between the federal and state and local law enforcement agencies.
All right, so what is 34 USC 21113?
The part that I was referring to with the standards is 34.2.1113. Actually, it's not two, it's 21114. And then 21114, section 7 says they must establish standards consistent with established norms to which such task force shall comply. And to further emphasize that, Your Honor, the documents that Ms. Basso presented today is pursuant to those standards, and it's in the investigative section of those standards. Attached to my second motion, the 2018 standards,
When was your second motion filed?
the one that she addressed when we first came up here.
That's not an answer.
I think it was filed on, actually, I have it here.
Appears to be
I think it's Friday.
8/1/25, Your Honor, at 8:43 PM, according to the clerk filing.
That the second motion for order to the state of Florida to comply with the discovery rules, is that what?
Yes, that's when I asked for the consent forms and the name of the person, which is required by the standards in Section 8 of the 2018 standards. Those are accessible on the internet.
What do you think you're due at this point, Mr. Johnson?
Excuse me, Judge?
What do you think you're due still?
An unredacted version of the 2023 version of the standards. If you look at the 2018 standards, it's actually on page 17. It deals with the investigative standards. Included in those standards are the use of photographs. Members
Page
shall.
17?
Excuse me?
Did you say page 17?
11 of 17.
Well, okay, that's the page I was on, but you said page 17, that's why I
Sorry.
asked the question. Go ahead.
But there, section 8.3 says that the members shall not use any visual depiction of any size except certain specifications. They have to be a member of the force, have to be over 18. They have to give their consent. And that's what Ms. Basso says she sent today. I mean, I haven't checked it out, but I assume it is. But that complies with that standard. When you get to the 23 standards that they supplied to me, they didn't give any of the investigative standards. These standards also talk about how they're able to conduct their investigation, how they lead conversations, which we contend didn't happen in this case. But that part is blacked out in the redacted version. And it was because of this standard that she is supplying that amended discovery exhibit in the consent form.
Provided in response to your motion.
Which refers to the standards.
So, Ms. Basso, who holds the unredacted copy of this?
Your Honor, if I were to need to look at it, it would be the ICAC Commander Chris King that we work with.
And what is he telling you? Why can't you get the unredacted?
Because they're not allowed to give those to us. That's the
Based
bottom
on
line.
what?
I believe that's DOJ policy. That was what I was told.
Well, but that's why I need to find out what these things actually are, not just, secondhand or third hand. This is what DOJ says.
That's exactly what I said when in contacting Chris King. He said, I cannot provide those, and you are not allowed to provide them either. Honestly, I don't know where the ones on 2018 ever got on the internet, because they were concerned about that originally too. We've had this previous discussion. I would suggest that, Mr. Johnson can contact Chris King and see if he will give him an unredacted copy or access to it. If it still runs into a roadblock, we can check back in. But that is my only way of knowing of how to get those would be through him. That is our contact.
Judge, I don't know if that's really true.
I can only tell you
Well,
what I know.
it sounds like neither side really knows what the situation is, and that's what I'm trying to get at. And everyone's saying, well, there's policy, or they're telling us
No.
this, but no one's really giving them anything concrete.
I can reach out to Mr. King and determine if there is something he specifically can cite me to so we can provide that. But all I know is that is always, ever since I've started working these cases, that has always been the policy. And
What is
that's,
Mr. Sergeant
he's the
King?
ICAC commander, Your Honor,
Who does he work for?
It's actually Gainesville Police Department, I believe, but he actually is the Northwest Florida ICAC commander. He handles the task force. So when there's an operation, that's kind of who.
That's a state task force, right?
It is a statewide task force, yes, sir.
Okay, so then this information is in the hands of state agencies.
Yes.
So then I would have to see what federal issue is preventing them from disclosing it. Otherwise, it'll have to be disclosed. I just need to see something officially that says that, and then the argument can be made.
I can reach out. That's not a problem.
Judge, the 3 statutes I provided you covers this. I mean, there has to be.
I understand it, Mr. Johnson, but this is not something that's normally argued. Your motion doesn't mention any of this U.S. code in your motion.
Right.
So I haven't had a chance
It
to
just
read
says-
through the volume of what you've just handed me about what these are, and so I can do the research into them.
The motion just said the law.
Say
But
again?
this is the motion said that law requires that these standards be published and they abide by
All right,
them.
so what you're saying is you file a motion that says the law requires, and then you wait until the hearing to actually provide the federal law to me to read.
And I will reach out to Sergeant King, see if I can get a concrete site for the court, and then I will, of course, provide that to Mr. Johnson prior to doing that.
Judge, the motion says it's a part of the Department of Justice program in conjunction with the Office of Juvenile Justice and Delinquency under the United States Department of Justice.
What page of which motion says that?
The first motion, page 1 and page 2, paragraph number 2.
And where in those paragraphs does it give me the specific U.S. code that you've now
The
provided me
code is
today?
not cited in the motion, just the standards.
And that's my point. So if you want me to prepare for a motion, you have to give me the things you want me to read in advance. Otherwise, I'm not going to go, I can't possibly research the entirety of what you've mentioned in paragraph 2 or 3.
I understand, Your Honor.
And it sounds like they've given some things over, but you just have to determine if you have everything. I think what's been discussed is talking to the person who's the liaison to this program that would actually have access to it. And if he refuses to give it over, find out why and under what code, provide that to me. I'll read it, and then we'll have another hearing as to whether or not I'm going to tell him to turn it over anyway.
I asked Sergeant King for the standards. He provided me what I filed with the court, and he redacted those provisions.
And what I'm asking for is if someone could talk to Sergeant King and ask him, under what authority can you redact these and not provide them through discovery, so that I can read that portion of it?
I will reach out, Your Honor.
I'm fine to look at this stuff, Mr. Johnson, but you've got to let me prepare for it by giving me these things in advance. None of these motions were sent to my office. What you're talking, you've filed a second motion after the notice of hearing was filed. So I wasn't even aware there was a second motion until you just mentioned it.
I think what you'll find when the standards say it's limited official use, law enforcement sensitive. That's on the unredacted and the redacted versions, the 23 and the 18. And I think Sergeant King made that decision, not the Department of Justice.
Well, then I have to know under what authority he's doing that. And it sounds like what we need to do is set a hearing where possibly Sergeant King testifies. So I understand what's going on here.
That's fine. We
I'll
might
reach
should
out
talk to
to him.
DOJ too.
Say again?
We might also talk to the Department of Justice.
You can
also.
certainly conduct your investigation into the case, Mr. Johnson. I'm not preventing that.
No, I'm
but-
talking about for the hearing.
Well, then you'll have to subpoena who you would like to subpoena to be here. I don't know what the issue is until I get to hear everything, but I don't subpoena witnesses. So if you think that someone from the DOJ needs to be a part of that hearing, you're going to have to procure their attendance.
I assume the state attorney's office had them because when we asked for the standards regarding the evidence of the photographs, they provided it pursuant to that standard. So I don't know how they knew the standard numbers, but they don't have them.
Your Honor, he specifically asked for the UC consent form. That's why I knew what to provide.
All right. Let's see what y'all can figure out. Set it for a hearing once you've had a chance to talk to Sergeant King. And I'm not telling y'all who you need to subpoena, who needs to be here, but I'm just suggesting that I might need to hear as to why it's not being turned over. And
Thank you, Your Honor.
Y'all get whatever witnesses you want for that purpose.
Sounds good, Judge. Thank you.
All right, thank you. All right, Mr. Kleins, are you ready on yours?
Sign it, dated here. It's August 7th. Your Honor, this is Mr. Nicosi Seals. He is signing an agreement to resolve the violation in this matter. Mr. Seals has previously been adjudicated. The agreement that he's executed with the state is that he will admit the violation in this matter. The agreed-upon disposition is that his prior term of supervision would be revoked and terminated. He would be placed on a new period of 2 years of community control. The only special condition that he would have would be that he attend and complete a substance abuse evaluation or the Emerald Coast Life Center program. That was an original term of probation originally. The cost of supervision would be waived. He would be assessed a $100 cost of prosecution and $150 for the cost of defense. May I approach? Yes, sir. And he has been adjudicated.
Thank you. All right, so it'll be a revoke and terminate of the original probation, 2 years community control.
Yes, sir.
New. Okay. All right, Mr. Seals, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth, please?
Lucy Stephen Shields, 9/22/1997.
All right, Mr. Seals, you're here in 24 CF 877 on a violation of probation. I've been given a plea agreement that calls for you to admit your violation of probation, revoke and terminate your prior supervision, enter a new 2 years community control with a substance abuse evaluation and recommended treatment, or comply with the ECLC program, waive cost of supervision, $100 cost of prosecution, $150 cost of defense. Is that what you want to do today?
Sir.
Is that the state's agreement?
Yes, Your Honor.
All right. Did you go over this plea agreement with your lawyer?
Yes, sir.
Did you sign it?
Yes, sir.
Did you understand it?
Yes, sir.
Are you satisfied with your attorney's advice and representation? This appears to be a downward departure as well. Is that correct, Ms. Leone?
Yes, Your Honor.
And what is the basis for that?
Uncoerced plea and need for treatment.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances, Mr. Seals?
No, sir.
And are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this admission?
No, sir.
Has anyone promised you anything in return for your admission? You understand that by entering admission, there won't be an evidentiary hearing where the state would have to prove how you violated your probation. Do you understand you're waiving all potential defenses that you may have?
Sir.
Do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea as to the violation of probation? Are you admitting or denying?
Admitting.
Accept your admission as freely, voluntarily, knowingly entered. Revoke and terminate your prior supervision. Sentence you to a new 2 years community control with a substance abuse evaluation or any recommended treatment, or to comply with the ECLC program. Waive cost of supervision due to the fact that you're indigent and represented by Regional Office of Conflict Counsel, $100 cost of prosecution, and $150 cost of defense. That is an adjudication. Anything that I've missed?
No, Your Honor.
It's only one case, so
That's
it's
correct.
concurrent between the counts. Yes.
You know, may we approach on another
Sure.
matter?
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestvew's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestvew's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So
Is there
you
Derek
have things to
Tolar?
do, go and do it.
Your Honor, I tried to call Mr. Tolar. I left a message at the only number I have. I had no contact with him.
I think he wasn't here last week.
That's correct. And I have been advised by the state, the basis for the violation was a new charge. That has been dismissed. However, Mr. Tolar has apparently, allegedly, tested positive for something. So there's going to be an amended violation report coming out. But
I guess send me the amended violation and
I believe the amended violation is being filed, Your Honor. I think they just got it yesterday, the results.
when was the UA taken? If you could, thanks. right, this is the one where it's listed as an attempted trespass.
Still awesome.
So when did that case get dismissed?
That was dismissed in county court in the middle of July. I want to say on July 6th, whatever it was.
July 23rd.
I happened to be walking past Miss Flowers when
My
she
system still shows that it's open,
Well, it's-
even though the clerk's minute sheet shows that it was null prost.
You have to dig down to get to that.
So is there going to be an amended affidavit?
Yes, Your Honor. The officer said it's in process. Just got it back.
When that gets sent over, I guess I'll have to issue a new reason to take him into custody.
I don't believe he was taken into custody on this particular one because of the charge. And so this one would be the first time probation will specifically ask to be taken into custody at that time, Your Honor.
This is on-site arrest status changed to served. What happened? He got arrested for the trespass and a PC arrest on the VOP.
Sounds about right.
He was given what appears to be a signature bond on each case at first appearance. Appeared on March 27th. He appeared on May 29th, where he was set for July 31st and didn't appear.
I'll defer to the court, however the court wants to handle that.
The state would ask for a capias in this case.
All right. Court's going to issue a capias in 2024 CF 1990 for Mr. Tolar, based on the fact that he failed to appear on July 31st. Again, that court date was announced when he was present on May 29th. And then obviously I'll deal with the VOP paperwork when it comes in.
Yes, sir.
Thank you. What? Oh, capias no bonds. Mr. Russell, did you have a chance to speak with Mr. Kleins about Ms. Edwards?
I did, Judge. I do have one suggestion before we go the route of withdrawing and appoint RCC, but I'll get Ms. Leon up here.
Mr. Kleins, did you talk to Mr. Russell about the Edwards case?
I did, Your Honor. Just based on what I've been told, my understanding is that if the source of the competency predates the plea, then I think I know it presents a tough question for the court, but the problem...
I'm looking for a good solution to the tough questions.
So the good solution, I think, is that the court should well,
Revoke and terminate and...
Well, I think the plea should be withdrawn. I mean, if the source of the incompetency predates the plea, then she was incompetent at the time the plea was entered. And I don't even think it's a 3850 type issue, because we've all had situations where if the client doesn't say something directly to us or behave a certain way in front of us, we don't pick up on the incompetency issue. Like, in the past month, I filed a motion for a comp eval on an individual that's in custody that I only gleaned the incompetency issue by talking with his brother and with a third party. Like, he had never said or done anything in my presence to cause me to question his competency. And then, of course, after I informed him, then he started saying a bunch of things that I'm like, okay, I feel comfortable with what's going on here. So the concern that I would have just from if I was still in the public defender's office, I'd say, look, I didn't know she was incompetent. You know, like, I inadvertently pleaded somebody to who apparently was not competent to proceed. And if she's not competent, then there's no way, I don't see how a court could say that this was a knowing and voluntary and intelligently made decision. So I think if the state would be willing to do it, dismiss the VOP, withdraw the plea, and essentially find her incompetent.
And then dismiss the original charge.
How am I dismissing the original charge?
No, have the state null pros the original charge.
Well, that would
Because
be
they
up to
can't-
them. Yeah.
Right, but that was going to be, my suggestion is dismiss the VOP, state stipulate to a withdrawal of her plea to the charge back in November of '24, stipulate to vacating the sentence, which would put her back to, she's facing the original charge, and then the state dismissed the charge, if they were so inclined. If not, then I don't know what we would do at that point. But she can't be tried because she's not competent, and she's not restorable.
My concern in looking at Rule of Procedure 3.170L, which is a motion to withdraw a plea after sentencing, which this would be, right? Defendant who pleads guilty or nolo contendere without expressly reserving the right to an appeal, a legally dispositive issue, may file a motion to withdraw the plea within 30 days after rendition of the sentence, but only upon the grounds specified in 9.140. So if the VOP is dismissed, and Mr. Russell, if the PD would file a motion to set it aside, the plea, and we could address it at that point. Would there be an objection from the state on that motion to set aside? I don't want to put you on the spot. I'll certainly give you time to do that, but.
I think at 3850. Still don't believe
Well, then, what is the state's position on the VOP?
the VOP can be dismissed.
VOP is dismissed. That's step one. Technically, she's still on probation until in some way the court could potentially set aside, whether that's a motion to set aside a plea, whether that's a 3850. I'll let y'all make the strategic decision on that.
But to dismiss the VOP and put her back on probation brings us back to the original reason we.
Oh, I understand that, but I try to make sure I always stay in my lane and only do what I have the authority to do, and not sua sponte just say, you know what, this is the right thing, so I'm just going to, in my opinion, do the right thing and just say magically we all get back to where it should be without the proper motions being filed, especially if the state has an objection to setting aside the plea. I can't just make it happen. I don't expect I'll get a violation of probation affidavit unless probation determines that there's something willfully being done to not comply with that. And I'm already allowing contact, which I think was the only issue, through the terms of her release.
If I may, that the state wouldn't be responsible for supervising her.
I mean, I agree with that, but then who's bringing this back in front of me if we're in that situation?
Judge, I don't have a problem with a motion to withdraw plea because as Mr. Klein's indicated, anybody could make a mistake and miss the red flags for a competency vow. I understand that. But the court just said it has to be done within 30 days. And so if I file the motion, the state's just going to object as untimely, and then we're still back to square one.
And which is why I can't just magically do these things on my own,
Understood,
because the state is objecting to it, and until y'all convince me there's a lawful reason or way for me to do that.
Yes, sir.
I mean,
One suggestion that I would have would be the public defender and the state contact their appellate attorneys in Tallahassee and explain the situation. This can't be the first time in Florida history that this has happened. So if we can get the appellate specialists on board and they might have an answer that we aren't aware of in this courtroom right now. So that would be my suggestion.
can y'all do that?
Can try, Judge.
All right. I'd like to put it on the August 28th date. She's technically still on probation, but she doesn't have to report, so there's nothing to supervise until the next date of August 28th at 9 o'clock. And I'll address it further from that point. But she's already basically reported because her husband drove her over to the previous appointment. Okay. So we'll have a decision within the next 3 weeks, so she wouldn't have to report again, right, until September.
Can we do August 28th at 2, Judge, to go with
2
the other
o'clock,
cases?
yes, that's fine. August 28th at 2 o'clock.
Okay.
I'm going to see if I can try to figure out, every time we've come up to the bench today, we've found some problem or issue that none of us has ever faced before. And I think between me, Mr. Russell, Mr. Kleins, and Ms. Leone, there's probably close to 100 years of legal experience. So we've got some things to figure out, but again, I can't just say, I think this is what I should do, so I'm just going to do it without any authority to cite that I'm even allowed to do it.
Understood, Judge.
We'll see you back on August 28th at 2 o'clock. Obviously, if you come up across anything, send it to me right away. I'd like to read it. I'll research it a little bit myself. I just don't know how I can set it aside without a written motion and a chance for the state to be heard.
Understood, Judge.
But it may be one of those situations, once you talk to your appellate gurus in your offices or in Tallahassee, that there may be a way to get to where we all know we're going to end up without taking too many steps and too much time and too many resources. All right. Thank you. Do you have a case number or? Okay. Please, that would be awesome. Thank you. When was a motion filed? I mean, I'm looking at 371. The last thing that was filed is in 2023, according to what I have. 370? I thought you just said it was in the 371. Who set it for today? Has the state had a chance to take a look at it? It looks like the request came to me on June 18th is when I received it, and I marked it to set it for a hearing, which my assistant reached out to the state and Mr. Humbert. Did you receive something from my office at all about setting a date?
What did you receive? Oh, well, mine was a response to your assistant, Your Honor, saying that it's okay for me to do it at this time.
Okay.
Yeah.
You're okay. You're okay to set the hearing? Is that what you're saying?
Yes, it was about whether I agreed to have the hearing, and I said it's fine.
But you don't have a file or anything to look at this point?
No.
Have you had a chance to in the past?
So this one doesn't have any notes.
No, Your Honor. What is the...
So he's more than 2 years into a 3-year probation. I guess the problem is probation doesn't have anything to tell me if everything's been completed.
They got the information. Let me see here.
I've got his DC number if you need it. I guess my concern is it's an aggravated assault, at least one of the cases. And I'm assuming the state hasn't had a chance to reach out to the victim in the case to see if they have any issue with it.
We have, Your Honor. I can read the note left by the victim advocate. So on the 370, it says that that victim is okay with him terminating probation. So that's in the 370. In the 371, oh, this one. Oh, I see. Well, the other, he prefers if defendant is not allowed a firearm to carry or to have in his vehicle or home. Victim stated if there can be something put in place for defendant not to carry, then he's okay with defendant terminating probation. The only thing that I can say about the statement of this victim is that he does not terminate, so until the end, he won't be allowed to have weapons. But that's what the victim stated, one of the victims.
mean, there's nothing I can do to restrict someone's access to a firearm if they're off probation and haven't been convicted.
And I realize that I said that based on the victim.
Oh, I understand. I'm just, what the victim has said is, I will agree to it as long as X happens, but I can't do X.
Yeah.
I guess the problem is we're all trying to scramble, Mr. Humbert, because I'm not sure. Apparently a clerk emailed you and just told you to show up, and no one told us. And it's not the clerk that we have here. So it's, nobody has a file. We're all trying to kind of do it by, spontaneously here. Sir?
He had completed all of his conditions, all his fines, however, due to the nature of his charges,
Okay. I think what we're going to have to do is set it for a hearing. I hate that you've sat all day, Mr. Humbert. Well, but I'm just, unfortunately, number one, we're having an issue with the clerk's office and making sure that we're getting paperwork processed quickly enough. But I don't even see there was an attempt to indicate to anyone other than you that there was going to be a hearing today. And so the state has certain responsibilities under what's called Marcy's Law. It's part of the Constitution that they have to talk to the victims in the case. Obviously, I've got to look at it if I'm going to make a decision. Probation's recommending that you not get off probation early due to the fact that you're what's called a violent felony offender of special concern because of the charge that you're charged with. So I'd have to look into all this, and this is not the kind of things I would normally make a snap decision about. So we can try to set it for a hearing where everyone's ready, but that would have to not be for at least 3 weeks.
Honestly, Judge, don't even worry about it. I have less than a year on probation, and it's not.
Oh, it's okay. If you want to pursue it, you can certainly get it set for a hearing.
I mean, yes, sir.
We can do it, we just can't do it today.
Right, yes, sir.
And so I don't want you to just be discouraged and say, I'm going to give up.
I just didn't want y'all to have to go through a hassle when.
This is our jobs. This is what we do every day. So we're fine to do it. We just have to have time to be prepared for it.
Yes, sir, no problem.
All right. So, why don't we set them on the August 28th date? Would morning or afternoon be better for you, Mr. Humbert?
Morning's fine.
All right. All right, so let's put on August 28th at 9 o'clock for purposes of the defendant's motion for early termination. And we'll see you back on that date. Everyone's been given their notice, and we'll see you back on that date. Mr. McDonald. All right, bring him in.
Okay. Perfect, okay. Thanks. Do I have a few minutes to run back to my car, Your Honor?
Oh, yeah.
Okay.
I mean, we're going to have to take some sort of break. I mean, we've been going for 3.5 straight hours.
No problem.
So you're good. In fact, once we're done with Mr. McDonald's case, I think that finishes our 9 o'clock docket. And I'd like to have a little bit of time to at least try to have something to eat before we go another 4 hours this afternoon. Yeah. All right. Mr. McDonald. We've got your 3 cases on the docket, which are 24 CF 1950, 24 CF 2917, and 25 CF 713. You're currently representing yourself, correct?
Yes, sir.
All right, and do you want to still continue to do that?
Yes, sir.
Do you want me to talk to you anymore about the advantages of having a lawyer or the disadvantages of representing yourself?
No, sir, you don't have to do that today.
Okay, I just want to make sure if there's anything, or because I think the last time we were here on a motion you wanted standby counsel, but after kind of discussing it with one of the public defenders, you decided you didn't want standby counsel, you just kind of needed some help getting some things done, but you still wanted to represent yourself.
Yes.
Okay. And I think we're here on a motion to dismiss, is that right?
Yes, Your Honor.
And that's in which case number?
That is, for the record, the 25 CF 000713.
7113, okay. And I reviewed it. And I know the state filed a traverse, and then you filed a motion to strike their traverse.
Yes, I did.
All right. Why don't we kind of work through it backwards then? What is your reason for striking the traverse?
Because on the grounds that the state's traverse is facially insufficient by the rule, Your Honor, under
Okay.
3.190D. And under the authority of the rule, C4, which I'm going to just call it short, C4, was required to file a Pacific traverse.
And what does that mean to you?
That means, under the rule, Your Honor, instead of just basically going there, in which I stated in the motion to strike in line, on page 3 in line 9, the state stated it was under no obligation to present additional facts consistent with the guilt. But the state by law is required to do so to defeat a motion to dismiss, and which I put case law in there, which is State versus Kemp. And the state was required in line 3, 4, 5, 8, and 14 and 16 to provide a more specific denial to a specific material fact or facts under the authority of the rule, 3.190C4, Your Honor. The Florida Supreme Court mandated this requirement in State versus Oberliesen, which is a Supreme Court case in 2000.
Okay, and what does that case say?
That case said, also it stated, and used this case in Blanco, State versus Blanco.
Well, tell me what the case said.
All right, it says that the court held that the state needed to do more than simply deny that material fact as listed in the motion to dismiss were the only facts upon which the state based its case on. Under written law, Your Honor, the traverse fails to comply with the rule 3.190D, and in furtherance, by law, the state is required to exclude every reasonable hypothesis of innocence. And that's
In a traverse?
yes, in State versus Upton, yes.
Give me the site.
The State versus Upton is 392 Southern Second at 1013, Your Honor.
All right, so I'm reading from State versus Upton, which is a 5th DCA case.
Yes.
Like the 4th full paragraph starts, unlike the standard to be employed by a jury when it considers the evidence on a C4 motion, all inferences are resolved against the defendant. Here, while much of the evidence is circumstantial, it cannot be said that the recited facts do not establish a prima facie case of guilt against the defendant. In considering such a motion, the trial court should not determine fact issues or consider the weight of conflicting evidence or the credibility of witnesses.
Yes.
If the state's evidence is all circumstantial, then whether it has carried its burden of excluding all reasonable hypothesis of innocence must be decided at the close of all the evidence. To withstand a motion to dismiss, the state need show only a prima facie case.
Yes. In which I read that same additional language also, which it often falls up under Caligula-Opolis too, which is a Supreme Court case which mandates that requirement.
All right, state have any position?
I don't believe that this case supports defendant's argument at all. I think the issue in this case was that the state had not filed a written traverse. However, it does confirm that all the inferences need to be resolved in favor of the state and against the defendant. I have written a specific traverse with specific denial of certain facts. And it cannot be a fishing expedition. I don't have to provide additional facts except a denial, and that was actually made under oath. The traverse that I filed, Your Honor, complies with the rules and specifically denies some of the allegations that this defendant is making. Based on the law, the court shall deny the motion to dismiss upon the state filing a traverse. And it also in State v. Oberholzer, 411, Southern 2nd, 376. It's a fourth DCA. The court states that it is unnecessary for the court to delve into the circumstances of the case in reaching its conclusion. In other words, a motion to dismiss should not turn into a trial to discuss the facts. So I'm asking the court to deny the motion to dismiss based on the fact that I filed a traverse pursuant to the rules, contrary to the allegation that this defendant is making. Another case, Your Honor, Ellis v. State, 346 Southern 2nd, 1044, states that the state is under no obligation to present additional facts consistent with guilt. Its only burden is to specifically deny the material facts as set forth in the motion to dismiss. I have addressed each single paragraph, although many of them couldn't even require a response, or I couldn't even make a response. I did respond. I denied particularly paragraph 3, 4, 5, 8, 14, 16. So the law is clear that the court must deny the motion to dismiss.
All right, any other argument, Mr. McDonald?
Yes, Your Honor, and the state relied on, within its motion to traverse, Ellis versus State, which also states that the motion to dismiss can establish a valid defense. Which is a first DCA case. And I have two other additional cases to support that. And also, there is no requirement that the facts be presented, be personally known to the defendant. And in addition, Your Honor.
Give me a second, Mr. McDonald. I'm
Okay.
trying to read the cases that y'all are citing.
I'm sorry.
Ellis versus State, among other things, says, while the rule does not require the state to allege any facts which negate the factual matters set forth in the motion to dismiss, the state must nevertheless, when it purports to deny material facts, deny those facts with specificity.
Yes, that's under the rule.
Any other argument either side wants to make?
Just pointing out that the specificity refers to the fact of addressing each single allegation of fact versus as opposed to a general denial.
Our traverse is we deny everything.
Correct. That's not proper, but addressing each single fact, it is.
All right. Anything else, Mr. McDonald?
Your Honor, I'm just for the record, I would like to say that it still fails under the requirement that they were required to file a specific traverse to each fact.
No, it doesn't say they have to do, they don't have to say it to each fact. They simply have to point out which fact they disagree is undisputed and that they deny it with specificity. They could agree to 95% of your facts, but if they disagree with one of them, that's all they're talking, that it has to be done. All right. I'm going to take it under advisement. I'm going to read the cases through, then I'll let Fergie make the argument, and I'll have an order for you, a written order for you. All right. Anything else we have to address with your cases, Mr. McDonald?
Yes, sir. I have the notice for the discovery was in on the July 9th. I have not received it for this case.
On which case?
This case, Your Honor.
This case.
We have sent in the mail the paper discovery. The other discovery, I have it here, but I need to make a statement. I have a note from my assistant about the digital evidence for which he provided with 3 flash drives last time in court. So he provided previously used flash drives for discovery. None were in packages and all showed signs of use, scratches, labels peeled off. Due to the fact that they were previously used, it was necessary for our IT department to review each drive before it could be inserted into an agency computer to make sure that it was not corrupted in any way that would affect our network. IT determined that one of the drives was corrupted, unusable. Neither of the others was large enough to accommodate the amount of the data due to video sizes. Because any external drives are normally provided by defense counsel if discovery is to be shared outside of the normal process, it was necessary to obtain a flash drive large enough to accommodate the amount of evidence. This was done at the state's expense. So I do have one for him. Discovery is being provided on the flash drive for 24 CF 1950, 24 CF 2917, and 25 CF 713. There are currently no videos for 25 CF 713, but they have been requested. If the cases haven't been resolved by the time the videos are received, they will be shared with Mr. McDonald. In other words, we don't have yet videos for the case ending in 713. Okay. I am retaining his flash drives because the ones that are usable may be enough to contain the evidence for that one case.
Okay.
For the 713?
Yes.
Okay.
They just haven't received the videos
I don't have
themselves
it.
yet.
Yes, sir.
Or they've been requested. Do you even know if they exist, or you just have a request in if there are any?
We have requested. I don't know the response.
Okay. All right, but it looks like the discovery exhibit was filed yesterday, 8/6. And so that you'll receive that in the mail. And the only thing is the flash drive, which, just so you understand what she's saying, the state bought a flash drive because the ones you didn't, that you gave weren't going to be enough. Because one of them was corrupted, which means it can't be used.
Bad.
Yeah. Usually brand new ones are given over, so there's some
Well,
concerns.
and Nara had requested that, but I didn't have any control over it.
Well, I'm not being critical. I'm just trying to explain to you why they have to do that. For the same reason I don't take flash drives from everybody and just plug them into court computers.
Yes.
Because we don't know what could be there.
So you don't want him, so I obviously cannot hand this to him. We would have to deliver to the jail. I spoke,
I don't think they're going to take it back there. I know we talked about it a little bit last time, or at least some recent time, Mr. McDonald, as to how you're able to watch things on a flash drive.
Yeah, they have a computer there, and they'll rehouse me to do that.
I understand. It's just who do we give the flash drive to so that you can.
Miss Oliver is not in her position there anymore, so I don't really know now. And that was just been recently changed.
While they're talking about that, is everything set up with the depositions at this point?
we don't have a time yet.
All right. I'll follow up on that. I just thought that was already in the works, so I'll follow up because we have to get, court security and court admin and all those people together to make sure there's a place available and security for it and everything else.
Yeah, I did send your assistant and also Sergeant Jenks screenshots of my calendar so that they could choose, but by now, dates
have
may be
changed.
filled, yeah.
So I remember last I heard, security wanted certain days where we didn't have a bunch of other court going on because they have limited resources as well.
Yes. I understand. I will deliver it to Major McDaniel. I did speak with her about it a few weeks ago, so.
All right, so it'll get to you, and then I'll follow up on getting the deposition dates set.
With the paper document I can have?
They mailed it to you.
They were mailed.
So if they're mailed yesterday, you should probably get them by tomorrow, I would say.
All right.
Anything else?
I have one other issue, Your Honor, or I have another pending matter, which is a motion for reconsideration of the bail.
Have you filed a motion? When?
I didn't get the memorandum yet from the clerk.
Okay, well, it hasn't been noticed for today.
No, it has not been noted for today, but
If I haven't received it, I can't see it. I don't know how I could reconsider it without knowing what was exactly said.
if you could give me one moment, I'll tell you the date that I filed it.
I'm not seeing it here. Is what I'm
Okay.
saying. Motion to strike.
On the 8th day of July.
8th jail. In which case was that filed then?
The 2917 case, Your Honor.
Looks like it was processed on the 15th. An envelope. You just want me to reconsider based on all the things that you argued at the hearing?
Yes, but there is one change. The state argued the fact.
As you understand, it's not really reconsider, if you're asking me to reconsider, it has to be based on what you've already said to
Yes.
me. Otherwise, you have to argue and show me there's been a change in circumstances.
Oh, okay. Same thing. Just keep it as it is.
All right, well, then if there's nothing new, then there's nothing for me to reconsider. So your motion to reconsider is denied. I will get you an order on the motion to dismiss, and I'll follow up on the deposition dates so we can get those scheduled for you.
Thank you.
Thank you, Mr. McDonald. Is that it for the 9 o'clock? How much time do you need to read? Do we not have a date already? Hold on just a second, Mr. McDonald. Well, we'll put you on August 27th at 9 o'clock for purposes of your pretrial conferences.
Okay.
It looks like you're not officially put on there, and I want to make sure that you don't just fall off the docket because we didn't put it on a date. So
All right.
that's the next criminal date I've got.
Okay, thank you.
All right, thank you, Mr. McDonald. We'll see you then.
Y'all have a good day.
You too. Why don't we do this? We're going to take a recess till 1:15. If y'all have a chance to discuss anything about the pretrial detentions, if y'all get to a point of agreeing on anything, I'll certainly address them quickly, but I'd rather take a little bit of time since I know some of y'all have rotated in and out of the room. I know me and the clerk and I think Steve have been in here for almost 4 straight hours.
So the court knows what's going on, Your Honor. With respect to Mr. King, the public defender does have a conflict. We represent a co-defendant. We are going to have to withdraw.
Which case, what charge was that?
That was the child abuse charge, Your
Child
Honor.
abuse charge.
Yes, Your Honor. And then the other case, we'll move forward with a bond hearing, certainly